Welcome to the court gallery. A routine traffic stop uncovers nearly a kilo of nastiness hidden inside a gift bag. With the evidence stacked against her, the defendant takes the stand and admits to the crime, but claims she had absolutely no choice. She rolls out a high-stakes duress defense, pointing the finger at shadowy cartel handlers who allegedly threatened her family. It's a massive legal gamble. And on cross-examination, the prosecution fires back with her own text messages that seem to show far more concern for profit margins than kidnappings. Will the jury actually buy this extreme excuse? Stay tuned. We're about to find out right now.
Record, Miss Heath has made it here. Miss Heath, you're an hour late. You're not to leave this courthouse until this case is disposed of. You just stay here in the courthouse itself unless I allow you to leave by court order. Okay? You need to talk to Miss Heath about what she's going to do.
Yes, sir.
I want to go outside and talk to her, Miss Heath. You're not to leave the courthouse until I tell you to. You understand?
And the jurors are coming up, so y'all need to take her that way.
All right.
The first thing I want to put on the record, it may have been previously stated at trial management, but I want to put on the record that I just filed a notice of appearance as co-counsel on this case. Mr. Middleton had advised Ms. Heath in advance that I would come in as a trial attorney with more experience and handle the case at trial in consultation with Mr. Middleton. Mr. Middleton is, of course, present in the courtroom and will be available to consult throughout the entirety of the trial. Both Mr. Middleton and I have discussed the options before Ms. Heath with her. I understand what the situation was at trial management. There was discussion of her having the ability to plea with a cap of 15 potentially, and with the state having waived the min-man. Of course, the min-man can't legally be waived unless the state were to orally amend to a different offense or orally amend weight that is alleged down to a lower min-man threshold. So the negotiated plea didn't work out. Ms. Heath understands that the only option before her other than proceeding with trial at this point is to enter an open plea. The state has indicated to us that if she were to enter an open plea, it would still only be recommending 15 years, which is the minimum mandatory sentence. I've advised Ms. Heath, and she is aware that if we go forward with the trial, the state very well may not be in that position. If she's convicted, they could recommend anything up to the maximum sentence in this case, which is 30 years.
You can put Ms. Heath under oath and ask her a few questions, because it is just about what you just put on the record, Mr. Prince.
Yes.
You do solemnly swear or affirm testimony about you to be the truth, the whole truth, nothing but the truth, so help you God. Yes.
All right, ma'am, you lower your hand and state your name.
Christina Heath.
Ms. Heath, you just heard the announcement, Mr. Prince, is that correct? You understand you've been charged by way of an information, trafficking in methamphetamine. I can't pull the information up right now, but it's over 200 grams. Is that correct?
Yes.
And Mr. Sullivan?
Yes, Your Honor.
And the minimum mandatory sentence for that is 15 years in the Florida Department of Corrections. You understand that? The maximum penalty is 30 years in the Florida Department of Corrections. Okay. You understand that the state has not indicated, I'm assuming Mr. Sullivan is his representations that the state would not be asking if you entered a straight up plea, not asking more than the 15-year minimum mandatory. Is that correct, Mr. Sullivan?
Yes, Your Honor. My intention would be to ask for 15 years if Ms. Heath were to open plea.
You understand that if you go to trial and you're convicted, it doesn't matter what the state represents to me, that the minimum sentence will be 15 years, but the maximum sentence could be 30 years in prison. It would be up to me completely. You understand that? regardless of what mitigation that you offer, what aggravation the state wants to offer. That it's still my decision if you go to trial. Actually, it'd be my decision if you entered a straight up. I certainly would consider the state's recommendations at this point in time. So do you understand all those options? All right, you need to speak with Mr. Prince or Mr. Middleton anymore. And are we getting ready to, we're going to bring the jurors in and go forward with the trial?
Yes, sir. With Ms. Heath indicating that she doesn't want to open plea to the court, even with the state's recommendation, we'd be prepared to move forward.
Okay. And we're just going forward on the trafficking amount. Anything we need to bring up prior to bringing the jurors in?
Not from the state, Your Honor.
Not from the defense.
And when the jurors are in, I am going to, who's going to do the opening? Mr. Prince?
Yes, Your Honor. I'm going to defer the opening to the beginning of the defense case in chief.
Okay. With that being said, I'm going to go ahead and just introduce you as co-counsel today.
Yes.
And then you can announce that you're going to defer. Or anything else from the state?
No, Your Honor.
Have a seat. Ladies and gentlemen, the jury, if you'll stand to be sworn.
Raise your right hand. You solemnly swear that you will and truly try the issues between the state of Florida and the defendant whom you shall have in charge, and true verdict rendered according to the law and the evidence, so help you God.
I do. They have a seat. Ladies and gentlemen, thank you for all being on time today. I appreciate your patience. I am sorry I had something that came up and I had to delay it. We're getting ready to start now. No more delay. I want to introduce you to Mr. Nathan Prince. He is no co-counsel on the case and just came on the case. Members of the jury, you have been selected and sworn as a jury to try the case of the state of Florida versus Christina Heath. This is a criminal case. Ms. Heath is charged with one count of trafficking amphetamine 200 grams or more. The definition of the crime charged will be explained to you later. You must decide this case based on the evidence presented and the law that I give you. Evidence consists of the sworn testimony of witnesses, exhibits submitted into evidence, and anything else that I tell you to consider as evidence. The state's charging document, which is called an information, is not evidence and is not to be considered by you as any proof of guilt. It is my responsibility to explain the law to you. It is your solemn responsibility to determine if the state proved its accusation beyond a reasonable doubt against Ms. Heath in accordance with the law that I provide to you. Thus, the province of the jury and the province of the court are well defined. They do not overlap. This is one of the fundamental principles of our system of justice. Before proceeding further, it will be helpful if you understand how a trial is conducted. At the beginning of the trial, the attorneys will have an opportunity, if they wish, to make an opening statement. The opening statement gives the attorneys a chance to tell you what evidence they believe will be presented during the trial. What the lawyers say is not evidence, and you're not to consider it as such. Following the opening statements, witnesses will be called to testify under oath. They will be examined and cross-examined by the attorneys. Documents and other exhibits also may be introduced as evidence. After the evidence has been presented, the attorneys will have the opportunity to make their closing arguments. Following the closing arguments by the attorneys, the court will instruct you on the law applicable to the case. After the final instructions are given, you will retire to consider your verdict. You should not form any definite or fixed opinion on the merits of the case until you've heard all the evidence, the argument of the lawyers, and the instructions on the law by the court. Until that time, you should not discuss the case among yourselves. Your verdict must be based solely on the evidence or lack of evidence and the law. Jurors must decide the case without distraction and only on the evidence presented in the courtroom. Jurors must not conduct any investigation on their own. This includes reading newspapers, watching television, or using a computer, cell phone, the internet, any electronic device, or any other means at all to get information related to this case or the people and places involved in this case. You may not visit places mentioned in the trial or use the internet to look at maps or pictures to see any place discussed during the trial. If you investigate, research, or make inquiries on your own, I have no way to make sure that the information you obtain is proper for the case. The parties likewise have no opportunity to dispute or challenge the accuracy of what you find. This is contrary to our judicial system, which assures every party the right to ask questions about and challenge the evidence being considered against it and to present argument with respect to that evidence. Any independent investigation by a juror unfairly and improperly prevents the parties from having that opportunity, our judicial system promises. You are also not permitted to communicate about this case with anyone, including your spouse, family members, friends, neighbors, and even your fellow jurors. No communication includes no in-person, telephonic, or electronic communication, such as emailing, text messaging, posting information on social media or a website, or any other form of communication. During the trial, the court may take recesses, and you will be permitted to separate and go about your personal affairs. It is important to remember that the prohibition on communicating about this case applies during these recesses, whether you're at the courthouse or elsewhere. If at any time you find yourself in a situation where others are discussing the case in your presence, leave that situation at once and immediately report the matter to the bailiff, who will advise me. If you would like to take notes during the trial, you may do so. On the other hand, of course, you're not required to take notes if you do not want to. That will be left up to you individually. You have been provided a notepad and pen for use if you wish to take notes. Any notes that you take will be for your own personal use. However, you should not take them with you from the courtroom. During recesses, the bailiff will take possession of your notes and will return them to you when we reconvene. After you've completed your deliberations, the bailiff will deliver your notes to me. They will be destroyed. No one will ever read your notes. If you take notes, do not get so involved in note taking that you become distracted from the proceedings. Your notes should be used only as aids to your memory. Whether or not you take notes, you should rely on your memory of the evidence and should not be unduly influenced by the notes of other jurors. Notes are not entitled to any greater weight than each juror's memory of the evidence. All cell phones, computers, tablets, or other types of electronic devices, including smartwatches, must be turned off while you're in the courtroom. You may use these devices during recess, but even then, you may not use your cell phone or electronic device to find out any information about the case or to communicate with anyone about the case or the people involved in the case. Do not take photographs, video recordings, or audio recordings of the proceedings or of your fellow jurors. After each recess, please double check to make sure your cell phone or electronic device is turned off. At the end of the case while you're deliberating, you must not communicate with anyone outside the jury room. You cannot have in the jury room any cell phones, computers, or other electronic devices. If someone needs to contact you in an emergency, the court can receive messages and deliver them to you without delay. Any juror who violates these restrictions jeopardizes the fairness of these proceedings, and a mistrial could result that will require the entire trial process to start over. A mistrial is a tremendous expense to the parties, the court, and the taxpayers. If you violate these rules, you may be held in contempt of court and face sanctions such as serving time in jail, paying a fine, or both. In every criminal proceeding, a defendant has the absolute right to remain silent. At no time is it the duty of a defendant to prove her innocence. From the exercise of a defendant's right to remain silent, a jury is not permitted to draw any inference of guilt, and the fact that a defendant did not take the witness stand must not influence your verdict in any manner whatsoever. The attorneys are trained in the rules of evidence and trial procedure, and it is their duty to make all objections they feel are proper. When an objection is made, you should not speculate on the reason why it is made. Likewise, when the objection is sustained or upheld by me, you must not speculate on what might have occurred had the objection not been sustained, or what a witness might have said had the witness been permitted to answer. During the trial, it may be necessary to confer with the attorneys out of your hearing to discuss matters that will require consideration by me alone. It is impossible to predict when such a conference may be required or how long it will last. When such conferences occur, they will be conducted to consume as little of your time as is necessary for a fair and orderly trial of the case. Mr. Sullivan?
Thank you, Your Honor. Counsel. February 2nd, 2025, members of the Bay County Sheriff's Office Special Investigations Division, the narcotics unit, were doing their job, keeping controlled substances and drugs off the streets of our community, when they came across this defendant, Christina Heath, who was trafficking methamphetamine, who brought almost 1,000 grams of methamphetamine from the state of Georgia down to our community. You're going to hear from Investigator Thomas LaRoche. He's one of those investigators with the Bay County Sheriff's Office today. And he's going to tell you that in February of 2025, Ms. Heath was traveling down Highway 79 and got pulled over for speeding. During the course of this traffic stop, K9 ran around the vehicle, alerted to the presence of narcotics, and the vehicle was ultimately searched. You're going to hear from Investigator LaRoche that he spoke with Ms. Heath, and she told him exactly where in the car he would find the drugs. And you're actually going to see part of that because Investigator LaRoche is running a body camera. You're going to see the photographs of Investigator LaRoche finding that package and opening it up, and you'll see what was found. You're going to hear that what was found in Ms. Heath's vehicle was sent to the Florida Department of Law Enforcement for testing. And you're going to hear from an analyst today, Rebecca Chandler, who's going to tell you that the substance that was found in Ms. Heath's vehicle was in fact methamphetamine, and that she weighed it, and it weighed over 900 grams. Now, we talked a little bit Monday during jury selection about what trafficking is. You're going to hear that I have to prove that this defendant either possessed or brought into the state of Florida more than 14 grams of methamphetamine. We talked a little bit about the different levels, and that the highest level of trafficking methamphetamine starts at the 200-gram level. And you're going to hear that this defendant, Ms. Heath, had almost 5 times that amount. Ladies and gentlemen, this should be a relatively short trial. It's not a very complex trial. You're going to hear from those 2 witnesses today. And I expect that after you hear from those 2 witnesses, there will be no doubt that this defendant brought that large quantity of methamphetamine to this community, to our county. And I ask you to find the defendant. At that time, I'll come back before you and ask you to find the defendant guilty of trafficking methamphetamine. Thank you.
I'm going to defer opening to the beginning of the defense case in chief.
Okay. Mr. Sullivan, you may call your first witness.
It's Thomas Stickles, Thomas LaRoche.
Remain standing. Raise your right hand. Madam Clerk.
Do you solemnly swear or affirm that you have to keep this culture and let the truth and help you God?
I do.
I'm sure you have a seat to speak into that microphone. And Mr. Sullivan, you may inquire whenever you're ready, sir.
Thank you. Good morning, sir.
Good morning.
Can you please introduce yourself to the jury?
Yes, my name is Investigator Thomas LaRoche.
Investigator LaRoche, where are you employed?
I work at the Bay County Sheriff's Office
How long have you been with the Bay County Sheriff's Office?
since 2019.
And what do you do as an investigator with the Sheriff's Office?
I work in the Special Investigations Division,
What is the Special Investigations Division?
Narcotics Unit.
Have you worked in the narcotics unit the entire time you've been with Bay County?
No,
How long have you been specifically working in narcotics?
since 2023.
I want to take you to February of 2025. You're obviously working narcotics at that time.
I was.
Generally, what do you do as a narcotics investigator?
We investigate all sorts of narcotics, trafficking to possession cases.
Did you have occasion to be involved in a traffic stop on February 2nd, 2025?
I was.
Where was that traffic stop located at?
We stopped the vehicle around School Avenue and Highway 79 near West Bay Elementary.
What was the purpose of the traffic stop?
Initially, it was for her speed.
When you say her, who was the individual that was stopped during this traffic stop?
Miss Heath.
Was she the only individual in the vehicle?
She was.
You see Ms. Heath in the courtroom today?
I do.
Can you please identify her?
She's the lady right here in the blue and white dress.
So this traffic stop is conducted, and what do you do? What's your involvement?
I observed the initial traffic, the probable cause for the traffic stop, the speeding itself. And then I arrived shortly after Deputy Mullah Turk, conducted the traffic stop.
Deputy Mullah Turk's the one who actually pulled her over?
Correct. He was in a marked vehicle.
You were not?
I was not.
So after Ms. Heath's pulled over by Deputy Smuggler, how long did it take you to arrive on scene?
Within maybe a minute or two.
Were you the only Special Investigations Division narcotics investigator to show up?
I was not.
Who else showed up?
Investigator Cummings, our canine handler, Sergeant Head, and Investigator Pettyjohn.
When you arrived on scene, what did you do?
I initially made contact with Miss Heath, asking for her driver's license and initial vehicle documents.
Was she ultimately removed from the vehicle?
She was.
What was the purpose of removing her from the vehicle?
Investigator Cummings had deployed his canine to deploy or do an open air sniff around the vehicle and told me that she positively alerted to the odor of narcotics emitting from the vehicle.
Based off of the canine's alert, what happened?
We did a probable cause search of the vehicle.
During the search, did you speak to Ms. Heath at all?
Investigator Pettyjohn did.
Did you make contact with her at all?
I did after the initial search.
Now, are you issued a body camera as part of your duties?
I am.
Were you wearing it that night?
I was.
Was it on for a portion of this search?
It was.
You may approach.
Showing you it's been marked for identification as 6 Exhibit 1. Is that a disc with your clip from your body camera on it?
It's a disc, and I would assume that my body cam is on it.
Have you reviewed your body camera prior to coming to court today?
I did probably a month ago.
Your body camera captures your interactions with Ms. Heath that night.
Yes.
It's time to say that you were 6 Exhibit 1 in evidence.
Any objection?
There you are.
State's Exhibit 1 will be accepted into evidence. You may publish whenever you're ready.
The screens. Audio, please. Investigator Lurch, when you first began searching the vehicle, kind of walk the jury through, I guess, how was a vehicle search conducted? What do you do?
I usually do my searches pretty much the same every time. I usually start at the driver's side. And I work my way around clockwise.
And when you did that in this particular case, did you find anything immediately?
I believe there was some things within arm's reach of Miss Heath.
Well, ultimately, you found a large quantity of controlled substances.
That's correct.
Did you find that upon your first look in the vehicle?
No, I did not at first. Investigator Pettyjohn advised me that he had spoke with Miss Heath and she had informed him that it was in the back seat.
I could have one moment, Your Honor. Yes. So after initially searching the vehicle, is that when you went over to Miss Heath yourself?
Yes, sir.
More than a key in the car? I'm gonna let you know something right now. I've been investigating you. I understand. I've been investigating you for a while. I know you've been coming down here from Atlanta. You were in Collier, whatever it was called last night. You've been up there for about 3 days, just south of Atlanta. This is where you live. Okay, so I know what you're doing.
I admitted it.
So where's it gonna be?
It's in a box right there in a gift bag.
The gift bag? In the front of the bag?
It's in the back.
Okay, the back.
I sit like in the middle.
Like where
Would you mind
people
me
sit in the back?
hand it to you,
No,
sir?
no, that's fine. I don't want you to grab nothing. Give me 1 second, okay? You can grab a camera real quick.
And after telling you that it was in a box in the gift bag, go back to the vehicle, did you search?
I went back to my vehicle first to grab a camera.
but ultimately you went back to.
Correct.
Take a search of her vehicle. Her vehicle had a lot of items, a lot of things in it, right?
Correct.
It was pretty full.
I would say so.
May I approach, Your Honor?
You may approach.
Showing you what's been marked for identification, it states 2A through 2I. We could just flip through those real quick. Those photographs represent what you found in this vehicle.
Yes.
So I'm saying which states 2A through 2I in the evidence.
A through I. Any objection?
No, Your Honor.
Today's exhibit A, was it 2A through I?
Correct, Your Honor.
Exhibit 2A through I will be accepted evidence. You may publish whenever you're ready.
Let's get a little rush. What we're looking at here is states exhibit 2A.
It's kind of blurry, but that white bag with the pink and blue on it, it's like a I don't want to say birthday, but like a present type bag that you would get from like Target or Walmart to put a gift into.
Okay.
Yes.
Now this green foliage in the upper right-hand corner, you see it had like a little tree in the back of the seat as well.
Yeah, some sort of plant.
States 2B. Is that same gift bag
It is.
as you take it out of the vehicle?
Correct.
2C. Was that box inside of the gift bag?
Yes,
Did you ultimately open it up?
I did.
Is that what you're doing here in 2D?
Yes.
2E? Is that how the box appeared as you first opened it up?
Yes.
Did you remove what's inside of the box?
Yes, we did.
Is that essentially what you're doing here?
Yes.
I want to focus on two things. You've got a black bag in your hands, but then there's still something in the box.
Yes.
What is that appear to you to be in the box?
It appears to be methamphetamine.
Was that bag that's still in the box in this photograph, was that collected?
The one at the bottom of the box?
Yes.
Yes.
Approach, Your Honor.
You may approach.
Marked for identification, it says 3A.
Okay.
Is this essentially what was in that box in this photograph?
It is.
In this particular exhibit, the items in the Ziploc bag that's depicted in that photograph are both in this exhibit.
That's correct.
That's why I'm saying it moves into evidence, states exhibit 3A.
Any objection?
No, Your Honor.
Today's exhibit 3A will be accepted evidence. You may publish whenever you're ready.
Now, that 3A, after it was collected, was that ultimately sent to the Florida Department of Law Enforcement for testing?
It was.
Now, you said you've been a narcotics investigator for several years. Have you had occasion to come across various controlled substances?
Yes.
How often do you say that you deal with controlled substances?
Probably at least 3 or 4 times a week, if not more.
Specifically methamphetamine, is that a substance you're familiar with?
Very much so.
How many times in your career as a narcotics investigator would you say you've come across and dealt with methamphetamine?
Hundreds, if not thousands.
Do you feel that based on your training experience that you are able to identify methamphetamine when you see it?
Yes.
Now, going back to these photographs in 2G, so in 2F, you've got this black package in your hand. In 2G, is that where you begin to kind of unravel that black package?
It is.
And 2H, is that what's found inside of that black package?
Yes, those 2 packages, yeah.
Okay. Well, so I want to focus on 2 things here. On the left-hand side, you've got the bag with the kind of the pink Ziploc top.
Yes.
Is that what's been admitted evidence is 3A that was found in the bottom of the box?
I believe so.
And in your right hand, you've got, it looks like the package has got a blue and a green Ziploc bag.
That's correct.
Is that what was found in the black package?
Yes.
Okay. Now, the package that's in your right hand with the blue and the green, is that what is depicted here too high,
That's
the
correct.
two separate bags.
Yes, they were both in the wrapper that they're sitting on top of.
Now, when you find items like this, you didn't separate them, did you?
I just took them out of that package.
So I guess that was a poorly asked question. When you found them, they were in two separate baggies like they're depicted in this photo.
Correct.
And when you collect them and put them into evidence, which you did in this case,
Yes,
you keep them separate, do you not?
that's correct.
Armad approach. I'm showing you it's been marked for identification states 3B and 3C. Are those the two baggies that are depicted in that photo?
That's correct.
At this time, the state remove 3B and 3C in evidence.
Any objection?
No, Your Honor.
You see, State Exhibit 3, B and C will be accepted in evidence. You may publish whenever you're ready.
Now, these two exhibits, were they sent off to the Florida Department of Law Enforcement for testing?
I believe so. I marked them to be.
Are you familiar with FDLE's rules on, what, sometimes they test drugs, sometimes they don't?
I know it changes quite frequently.
In your experience as a narcotics investigator, have you sent drugs for testing and then FDLE will only test some of them?
Yes, absolutely.
Based on your training and experience, are you able to testify to what the substances are in all three of these bags?
I can tell you what I believe them to be, yes.
And what is that?
I believe them all three to be methamphetamine.
Now, you mentioned that, well, let me back up. After collecting these substances, did Ms. Heath have a cell phone on her when she was pulled over?
I believe it was in the vehicle, yeah.
Was that collected as part of your investigation?
It was.
Did you get a search warrant to search that cell phone?
I did.
After the search, was the search warrant granted?
It was.
And after you received that search warrant, did you conduct a search of Ms. Heath's cell phone?
I did.
Were there messages that were located in Ms. Heath's cell phone that you reviewed?
I did.
If you could look in the book of photographs, if you could look at State's Exhibit 4A through 4L. Investigator Lorch, do those photographs depict the messages that you found in Ms. Heath's cell phone?
Yes.
Now it's time to say we move States 4A through 4L in evidence.
Any objection?
No objection.
States 4A through L will be accepted in evidence. You may publish whenever you're ready.
Investigator LaRoche, I want to talk about some of the evidence a little bit in this case. You sent the suspected methamphetamine to Florida Department of Law Enforcement for testing. Did you request fingerprints or DNA on any of these items?
I did not.
Why not?
She admitted ownership over it on the side of the road.
You mentioned that you were not the only investigator that was involved in this.
That's correct.
I think you testified earlier that Sergeant Jeremy Head was present.
That's correct.
Did you see Sergeant Head present on scene?
I did.
Was he also wearing a body camera?
I believe so.
Did Sergeant Head speak with Ms. Heath at all during this interaction?
I believe he did.
Approach on.
May approach.
Stringy, what's been admitted into evidence as State's Exhibit 5. The body camera footage that, or the body camera that Sergeant Head was wearing, did that capture this interaction with Ms. Heath?
I believe it did, yes.
It's time to say we move State's Exhibit 5 in evidence.
Any objection?
No, Your Honor.
States Exhibit 5 will be accepted in evidence. You may publish whenever you're ready.
My name's Sergeant Head. I just want the, you do Miranda? Yeah. Super popular, very nice.
Just been trying to pay my papers.
What do you got in the car? Yeah. You have a camera? You guys got a break? Coke or meth? Meth. Okay. Where's it at?
I told him where it was at. It's in a gift box.
Investigator Lawrence, is that essentially your involvement in this case?
Yes.
No further questions, Your Honor.
Yes.
Questions?
Good morning, Investigator LaRoche.
Good morning.
One of the things that you do after finding drugs in a vehicle search situation is weigh the drugs, correct?
That's correct.
All right. And the total weight of the drugs found inside the Amazon box that you showed us pictures of was 1,286 grams. Is that right?
Altogether, yeah.
Together. I just want to ask you to reconcile one thing for me. You did an incident report in this case, correct?
I believe so, yeah. Yes.
Okay. Your Honor, may I approach?
May approach.
That's your report, right? Or a copy of your report?
Yes.
While I'm here, I want to ask you, you indicated a minute ago that the total package weight for the drugs found in the box was 1,286 grams, right?
If that's what I put in the report.
Well, that's what I want to ask about. So could you reconcile for me right here? You indicate item number 1, and then you indicate the quantity is 1,253, description 1,253 grams of methamphetamine. That's the same, we're talking about the same drugs, right?
That's correct. There's also another one down below, 0.3 here.
Mm-hmm. So is that the distinction between item number 1 here that's 1,253 and what you were talking about 1,286 before?
I'd have to read my investigative report again to see why I separated it that way.
Sure. Would it refresh your recollection if I let you look at the report?
Yes. I meant the actual investigative report, not the incident.
All right, I approach the witness again.
May approach.
For the record, is that your investigative report that you were referring to?
Yes.
Same question for that. That'll refresh your recollection, correct?
Yes. I'm assuming it must have been some sort of clerical error.
But just to be sure, make sure that we're talking about the same drugs. May I approach again, Your Honor?
May approach.
And I'm referring back to his incident report now, not the investigative report. This item right here that you listed as 1,253, item number 1.
Mm-hmm.
We're talking about the same drugs. These are the drugs in the Amazon box, right?
That's correct.
Okay. Now, you indicated you sent the drugs to be tested to FDLE in this case, right? Florida Department of Law Enforcement.
I noted for them to be, that would be our evidence technicians that actually send it, but yes.
I got you. And it's important to do that because even though you do have training experience and that looks like methamphetamine, it's possible that it might not be, right?
That's a possibility, yes.
Is it true that sometimes drug dealers like cut other substances, non-narcotic substances with drugs to be able to sell more of it like basically expand their profit margin?
We've seen drug dealers cut drugs before with other substances. I've also seen fake substances where it's not actually methamphetamine, but you can usually tell when it's a fake drug.
Sometimes not though, right?
When it's cut, yes, you usually can't tell if it's cut.
You can tell if it's cut. But
You cannot.
cannot tell. Okay. All right. And there are other substances, both illegal drugs and other substances that could look similar to methamphetamine and fool you more or less, right?
I've had people try to sell me fake drugs, but I've usually spotted it.
Well, I guess I just make the point. You send the drugs to FDLE because they do chemistry testing. I
That's
just want to be sure, right?
Yes, sir.
Like it is possible that you could be wrong.
It is a possibility. Yes, sir.
And besides just looking different, like some drugs may be chemically similar, but not chemically identical. Is that right? Like,
Yes, sir.
if you guys use, for example, a field test kit, methamphetamine and MDMA are similar enough that it could make it pop for the same test as MDMA and meth, correct?
The tests for MDMA and methamphetamine are the same test kit.
They're not the same test kit?
No, they are the same test kit.
And that's because they're, well, not the same drug.
They're very similar.
Chemically similar, right?
Yes, sir.
Okay. And so bottom line, in order to be sure about the drug before you charge somebody, or I guess it's after, but before you bring the charges to the state attorney for prosecution, you send it to the Florida Department of Law Enforcement to make sure that it's what you think it is, correct?
Yeah, they confirm our,
Yes, sir.
our field test.
I don't have any other questions at this time.
You redirect.
Yeah, just quickly, the 1,200 number that you have in your report, that includes all three of these packages, correct?
That's correct.
Okay, I've got no further question on it.
Anything else? Can the witness be excused?
I asked that he remain under subpoena, Your Honor.
Or you're still under subpoena, you can leave, you need to leave the courtroom, however, be available to call back to testify. Mr. Sullivan, you may call your next witness.
Rebecca Chandler. I approach, Your Honor.
You may approach. If you have a seat, speaking to that microphone, Mr. Sullivan, you may inquire whenever you're ready.
Thank you, Your Honor. Good morning, ma'am.
Good morning.
Please introduce yourself to the jury.
My name is Rebecca Chandler, first name Rebecca, last name Chandler.
Ms. Chandler, where are you employed?
I'm employed with the Florida Department of Law Enforcement in their forensics labs.
What do you do with the Florida Department of Law Enforcement?
I'm a crime laboratory analyst in the seized drugs department.
How long have you been with the seized drugs department of FTLE?
Over 3 years now.
And what type of education, training, background do you have that allows you to do your job?
I have a bachelor's of science degree in chemistry from the University of West Florida and a master's of science degree in chemistry from Florida State University. And I've completed a 13-month training program provided by the Florida Department of Law Enforcement.
And as a analyst in the seized drugs section, what do you generally do as part of your day-to-day job?
Day to day, I analyze items of evidence for the presence or absence of a controlled substance, and then write a report based off of my findings.
And with your time at FTLE, how many times would you estimate that you had occasion to analyze some item to determine whether it's a controlled substance or not?
Including my training, it's close to maybe just under about 10,000 times now.
Specifically, have you dealt with items to determine whether it's methamphetamine?
I have,
Can you estimate roughly how many times you've dealt with methamphetamine?
probably half of the time.
As part of FTLE, do you undergo what's called proficiency testing?
I do.
First off, what is proficiency testing?
Proficiency testing is when a sample is provided to me. It is treated as a case sample. I analyze that item as I would any other, and then write a report and submit that report. And another report is generated on if I have completed it correctly or not.
And how often do you undergo proficiency testing?
Annually.
Have you ever testified as an expert in court before?
I have
How many times?
close to 25 times now, including depots.
FTLE, that's an accredited organization.
It is.
That means you have standards and procedures that you must follow.
That is correct.
All right, this time I'll attend to the witness for Wadi.
Prince,
No, Wadi. Ask that she be able to render an opinion.
you may render her opinion.
Now, Ms. Chandler, were you submitted evidence in this particular case?
I was.
What were you submitted?
I was submitted a sealed clear plastic bag that contained 2 different clear plastic bags. One was heat sealed that contained a crystalline substance, and one contained a crystalline substance residue.
May I approach, Your Honor?
May approach.
Stringer has been admitted in evidence in State's Exhibit 3A. I believe it's got FTLE item number 1 on it. You recognize that?
Yes,
Is that the item that was submitted to you to analyze?
it was.
Now, can you walk the jury through kind of your process and your analysis when you receive an item like this?
So prior to receiving an item, my supervisor will assign the case to me. I will then, when I'm ready to work the case, I will request that the item be transferred into my custody from our vault. It is brought up into our section from the vault by a forensic technologist in the section. She then transfers the evidence to me, and I will store it in my secure locker until I'm ready to work the item. Once I'm ready to work the item, I'll remove it from my locker. I will document the outer and the inner packaging, as well as the item and anything inside of the packaging. I will then obtain a weight of the item followed by a chemical color test or 2 chemical color tests, and then 2 instrumental analyses.
What are those instrumental analyses?
Gas chromatography, mass spectrometry, and gas chromatography.
What is the purpose of doing the chemical color test and then the 2 instrumental analyses?
The chemical color test is a presumptive test. It can give me an indication of what the substance of interest may or may not be and at what concentration, so I can gear my sampling for the instruments based off of that color test. That way I'm not overwhelming the instrument. And then I can then take a subsequent sample for the instruments using the appropriate solvents.
And what do those instrumental analyses ultimately tell you?
They tell me what the identity of the substance is.
And is that what you did in this particular case?
It is.
Were you able to determine the chemical analysis of what that substance that you received is?
I was able to make an identification, yes.
And what were you able to identify that substance as?
Methamphetamine.
Did you weigh the methamphetamine in this particular case?
I did.
How do you go about weighing the methamphetamine?
For items, I will put a piece of paper or a weighboat onto my balance, and I will hit what is called the tare or 0 button, and that makes sure that the balance reads 0 and subtracts that paper from what I'm about to weigh. I will then put the substance of interest into that weighboat or on that paper and place it onto the balance and record that weight.
Now, as we sit here today, the methamphetamine is in several plastic bags. Do you weigh the methamphetamine inside of those packaging, or do you weigh solely the methamphetamine itself?
I weigh solely the crystalline substance or substance itself. Yes.
And in this particular case, were you able to determine the weight of the methamphetamine?
Yes.
And what was the weight of the methamphetamine?
984.69 plus or minus 0.21 grams.
Now, you mentioned that your supervisor assigns you the case.
That is correct.
Would it be the supervisor's job in determining what exhibits FDLE accepts from the agency?
Yes.
Are you familiar with FDLE's policy on testing multiple drug items? And sometimes, I guess let me ask you this way. Are there situations where you receive multiple drug items for potential analysis, but you only test some of them?
Yes.
And why is that?
There is a policy at FDLE to test substances to substantiate the highest charge per defendant per submission, or to work all trafficking cases.
And in this particular case, the highest charge for trafficking methamphetamine would be the 200 gram level.
It would be the 400 gram level for this.
Okay. And that's okay. I understand what you're saying. In this particular case, that exhibit is more than 400 grams.
That is correct.
So, may I approach, Your Honor? May I approach? So if the agency had also submitted these 2 smaller bags of methamphetamine for analysis, would that have been something that you would have analyzed as well, given you reached that 400 gram threshold already?
No.
Is it likely that your supervisors would not have even accepted those bags, given the weight of the other bag?
That is correct.
I've got no further question, Your Honor.
Chris?
Very clear, Your Honor. Ma'am, when you receive drugs to be tested from a law enforcement agency, is one of the things that you receive in the submission packet from them and then an electronic packing slip that lists the different items of evidence to be tested potentially?
There is one generated in our evidence section that I would not see.
Okay. May I approach you? Sorry, may I approach the witness?
Yes,
You're not the one that said it. Is this document that I'm showing you the electronic packing slip for this case?
It's something similar, yes.
But this is the actual form for this actual case, correct?
Yes.
Okay. And I want to ask you about these 3 packages of suspected methamphetamine here. First, I'll ask you about the total package weight for those 3 items. What were the individual total package weights for those 3 exhibits?
Sorry, I just want to make sure.
Sure.
So to just read those 3 out.
Yes, ma'am.
For item 3, the one I analyzed, total package weight was 1,035.9 grams. For what was listed as item 4A, 134.2 grams. And for the item listed as 4B, 155.3 grams.
All right, and you indicated to Mr. Sullivan on direct that you yourself weigh the weight of the drugs without the packaging, correct?
That is correct.
And what was the weight of each of those three individual exhibits without packaging?
Item 4A and item 4B never was received into the lab, so I never weighed those or worked them.
Yes, ma'am.
But for item 3, it was 984.69 plus or minus 0.21 grams.
Yes, ma'am. Thank you. And just to be clear, the agency exhibit, meaning the exhibit number assigned to the item by the submitting law enforcement agency for the one you tested was agency exhibit number 3, correct?
That is correct.
And then you didn't weigh or test agency exhibit numbers 4A or 4B, correct?
That is correct.
You didn't test those, correct?
I did not test 4A or 4B.
Thank you. No further questions.
You redirect.
Yes, Your Honor. I want to talk specifically about the item that you did. So your testimony that it's 984 grams of methamphetamine.
Yes.
Mr. Prince asked you about the total package weight, and I believe you read off it was 1,035 grams.
That is correct.
Now, total package weight is different than what you or what you weigh.
That is correct.
Total package weight includes all of the baggies that it's in as well.
That is correct.
And specifically regarding these numbers, you're not familiar with what scale this is, sorry.
No,
You don't know if that scale was accurate or not.
that is correct.
You don't know if that scale, had ever been aired like you mentioned.
That is correct.
And that's why you do your own weighing of the methamphetamine itself.
Yes.
Or for the.
Anything else for this witness?
Oh, yeah.
Can she be excused?
Yes, sir.
Ma'am, you may go about your day. Mr. Sullivan, you may call your next witness.
Some state rest.
Ladies and gentlemen, we're going to take our morning break. It's 11 o'clock. We're going to take a 15-minute break and start back at 11:15. Leave your notepads in the courtroom. Do not discuss the case among yourselves or with anyone else. Don't check any media sources or use your electronic devices to find out any more about the case you know right now. If you see anybody you see in the courtroom, do your best to avoid them. I'm telling them to do the same thing if you'll follow the bailiff in the back. Thank you. Chris, do you have a motion?
Oh, yeah.
We ready to go forward?
Your Honor, after discussing it with Ms. Heath, she is indeed going to testify.
Okay.
I've explained to her that she doesn't have to testify necessarily, and that, again, if she didn't testify, that the court would instruct the jury, as it did previously, that they're not allowed to hold that against her. It is a matter of strategy that she needs to testify here because she had essentially abandoned voluntarily participating in the conspiracy, but was being threatened to continue doing so. That evidence is not in the record right now. I've explained to her that the only way to that affirmative defense is to testify, and so she wishes to testify.
All right, I'm going to ask her a few questions about that decision. Ma'am, if you'll raise your right hand. State your name, please.
Christina Heath.
Ms. Heath, Mr. Prince has indicated that you made the decision to testify in this trial.
Yes, sir.
You understand that's your decision to make?
Yes, sir.
That it's perfectly advisable and to listen to your advice of counsel, but ultimately that decision to testify is yours. You want to remain silent. You understand that?
Yes.
You understand if you testify, if you answer Mr. Prince's questions, that you'll have to answer the cross-examination or have to be subject to cross-examination by Mr. Sullivan. You understand that?
Yes, sir.
You just can't stop after your testimony or your direct examination, yet that you'll have to answer the state's questions.
I'm sorry, can you repeat that one?
Yes, ma'am. Mr. Prince is going to call you as a witness. He's going to ask you questions.
Uh-huh.
Once he finishes those questions, the state, through Mr. Sullivan, will have an opportunity to cross-examine you.
Yes,
So
sir.
he's to ask you questions.
Yes, sir.
That you have to answer those questions if you make the decision to testify. You understand that?
Yes, sir.
You just can't stop it halfway.
Yes, sir.
Is anyone making you testify?
No, sir.
Are you doing this of your own free will? Are you under the influence of any drugs or alcohol today which would impact your ability to make this decision? Have you been diagnosed with a mental illness that would affect your decision to make, affect your ability to make this decision?
No, I haven't been diagnosed.
All right, you understand that up until the time Mr. Prince calls you as a witness, you can change your mind. That if you think about it and the jurors come in, and before Mr. Prince calls you as a witness, and you to change your mind, you can let him know, and he won't call you as a witness. Do you understand that?
Yes, sir.
Mr. Sullivan, Mr. Prince, Mr. Milton, are y'all satisfied with those questions and answers?
Yes, sir.
All right, can we bring the jurors in? Let the record reflect all the jurors are back in their place. Mr. Prince, you may give your opening.
Thank you. Morning, ladies and gentlemen. My name is Nate Prince, and I'm sorry I wasn't here with you for jury selection. I was picking another jury. Mr. Middleton and I were cooperating on cases a lot of times. But same as with the state's opening statement, this is an opportunity for me to tell you what I expect the defense evidence to be. Let me just acknowledge, like, this seems like a pretty clear-cut case, right? You stop the vehicle, only one in the vehicle, she's got drugs, she tells them before they even find out what it is, boom, 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 that should be it. But I expect that the judge will instruct you at the end of this case that in Florida, there are certain types of defenses that are called affirmative defenses. And one of those is that I expect the court will instruct you about is called the duress or necessity, all right? And Ms. Heath is going to take the stand. She's going to waive her right to remain silent and have you not consider that against her. And she's going to tell you how she got into this position and what was happening on the date that she was arrested here. So backing up, several years before this offense occurred, she had gone to Hawaii because her daughter and her son-in-law were having health problems related to a vaccine that they had received. They're both in the military stationed out there in Hawaii and were having all kinds of health problems. So she goes out there to help them. She's out there for a couple of years. While she's out there, shortly before she comes back and came back because she had to get medical treatment, she was injured badly, helping them move something that was real heavy. She'll tell you about that in more detail. The bottom line, her health insurance wouldn't apply out there. So she had to come back to Florida after trying to pay bills and everything. She's in a tough financial position and ends up through a sequence of events, making some bad decisions that got her in with some bad people. The way that went was basically her other daughter had a boyfriend that was in prison. Some business transaction, illicit or otherwise, don't know for sure, but some business transaction that he had with somebody on the outside of prison went in a way that person owed him money. And he asked her if she could pick up money for him and send a picture to show that he had received the money that he was due. So she did that. She sent money, she picked up the money, sent him the picture of the money, and he was supposed to be sending it to some other person who Ms. Heath didn't know that person or who they were or anything else. But for whatever reason, the daughter's boyfriend, who was incarcerated, couldn't forward the picture. So that guy provided contact information for Ms. Heath so that she could show that the money had been received and send that person the picture. Shortly after that, she starts getting contacted by that person. Now, at that point, she doesn't know that this person has anything to do with a cartel or anything like that. She just knows that this person is now offering her, hey, that was nice of you to go pick up money. Would you like to make some money? And talking back and forth. Now, to be clear, she knows at that point and is being explicitly asked at that point to engage in illegal activity, pick up drugs, run drugs for a fee. That's what this person is asking her to do. Now, you're going to hear about communications that she has with this person. This person is not the one that she's afraid of. She's been communicating with this person sort of flirts with her. And while it does ultimately turn out that person is cartel affiliated, that person is never who she's afraid of. That person is never the one that threatens her. But she does this. She willingly, knowingly engages in a conspiracy and does deliver drugs for this person. At some point, she wants to be done. She's done this for a couple of months now. She wants to be done. She doesn't want to do it anymore. That's when she finds out that this person is cartel affiliated because she is not allowed to get out. At that point, cartel members start showing up. They take pictures of her kids working at her shop. They show up at her house in ski masks parked in the driveway. Her dad moves away, flees, arms himself, and goes to live someplace else because he's afraid. She's afraid for her kids. She gets calls and they tell her that they're going to kidnap her daughter and force her into human trafficking. So she is afraid. And so she agrees to do it. But at this point, it's not voluntary. Now, this isn't a situation where the gun is literally pointed at her head or that her daughter is in a trunk being, taken to Mexico as they speak. But she also wasn't obligated to do anything yet. The threat became real and imminent. She'll explain to you when they wanted her to go deliver the drugs for them, bring them back the money. That's when it became real. And so at some point shortly before her arrest in this case, that's when she got the call. She had to get the drugs. She had to deliver the drugs. She did what she was asked to do, and she got caught. And she cooperated with law enforcement. She told them, like, everything that she told them is not on the side of the road right there. She goes and she tries to help them. And she'll tell you, like, she knew at that point, like, the reason that she couldn't go to law enforcement before is because she was being watched. They're following her, they're taking pictures of her kids, all of that. They know where she is while she's still an asset to them, while she can still deliver stuff for them. Once she's burned, they don't want anything to do with her. Why would they? Why would they work with somebody who's, you know, been arrested and ostensibly has reason to cooperate with law enforcement? So she'll tell you herself, that's why she was comfortable talking to law enforcement afterwards when she'd been burned, but not trying to go to law enforcement beforehand when she knew she was being followed and knew at any point they could hurt her or her daughter or her father or anybody else. At the end of the trial, then, I expect that the judge will instruct you on the necessity or duress defense, and there are elements that you will consider, and you'll have to make a decision about, under the circumstances, whether a reasonable doubt exists about that defense. I just ask that you remain open-minded, follow the court's instructions in evaluating the evidence, and make the decision that's compliant with the law in this case, which I would submit will be not guilty.
Next, they call you first witness.
Your Honor, at this time, we'll call Ms. Heath.
Just go forward and remain standing to be sworn. All right, ma'am, you can have a seat. You'll speak directly to the microphone. Mr. Prince, you may inquire whenever you're ready.
Thank you, Your Honor. Ms. Heath, can you please start by stating and spelling both your first and last name for the record?
My name's Christina Heath, and it's CHRISTINAHEATH.
I want to just kind of cut to the chase and walk the jury quickly through kind of what led up to you finding yourself in this situation. So about how long you got before you got arrested in this case, did you go to Hawaii to help your daughter and son-in-law?
It was probably about 2.5 years
Okay,
since I first went to Hawaii.
all right. And so how long were you there for? How long were you helping them out?
I was there for 2 years.
And at some point, did something happen over there to you?
Yes, sir. I was moving them and I got crushed by a dresser. No one was helping me.
Okay. And you don't have to go into details, but were you very seriously injured in a way that would require different types of
Yes.
medical care and treatment
Yes, sir.
to include surgeries and things like that?
Yes, major abdominal surgery.
Okay. And were you able to get that treatment in Hawaii?
No, sir. My insurance wouldn't work over there. I had to come home
And where was home?
to Georgia.
Okay. Roughly how long, you don't have to know exactly, but roughly how long was that you came home to receive treatment before your arrest in this case?
Maybe 8 months,
Okay.
9 months.
Now, at some point after you came home, you have another daughter, right? Not the one who was in Hawaii?
That's correct. I have another biological daughter, and then I have several adopted daughters, you know,
Okay.
the ones that grew up at my house.
All right. Now, your daughter who is over here, not the one in Hawaii, did she have a boyfriend who is incarcerated in prison?
Yes, that was my adopted daughter,
Okay. Your adopted daughter, okay.
my adopted daughter.
At some point, were you asked to pick up money that was owed to him?
Yes, sir, I was.
Can you explain kind of how that went and why you, and like just what happened there that you found yourself picking up money for your daughter's boyfriend in prison?
Well, he trusted me to go get it, and he knew I would make sure that he got the money back, and he offered me a few dollars to go get it.
How long had you known him for?
A few years.
Okay. So it wasn't like you just met this guy or met him while he was in prison or anything like that?
No, I didn't know him real well, but I knew we passed, you know, in passing. She didn't start really dating him on a regular basis until after she moved out of my house.
Okay. So regardless, you do agree to go pick up the money that was owed to him. Is that right?
That's correct.
You're gonna get paid for that?
That's correct.
All right. How long would you say that was before your arrest in this case? Just again, roughly.
Maybe a couple months.
Okay. Now,
I'm not sure exactly how long it was.
Yes, ma'am, I understand. So I guess tell me how that goes. Like you're supposed to go get money. Do you pick it up at some point?
I did. I went and met him at a certain location.
Was that up there in Georgia?
It was.
Okay. And you were supposed to send him, meaning the daughter's boyfriend who's in prison, a picture of the money to confirm you received it?
That's correct. I sent a picture to confirm the amount and everything.
Okay. And you were going to get paid for picking it up?
Yes, sir.
All right. Now, did you send him the picture like you were supposed to confirm receipt of the money?
I did.
And was he able to provide that picture to whoever it was he was supposed to provide that picture to?
No, he wasn't. Something about the signal in the prison.
Okay. So what did he come up with as an alternative so that whoever he was trying to confirm receipt of the payment for would know that you had picked up the money for him?
He gave me a phone number and told me to send it to that number.
Did you do that?
I did.
At some point after that, did that person or somebody using that number start communicating with you further?
Yes.
And how did that go?
He just started talking to me at first, and he knew I needed to make some money after we were talking.
And so how did he propose you make some money?
And by hauling stuff for him.
Illegal drugs.
Mm-hmm.
And to be clear, at that point, nobody threatened you.
Nobody threatened me at that point. No, I was just trying to make money to pay my bills.
Yes, ma'am.
My health insurance.
And you did understand that it was illegal to do that, correct?
I did.
Okay. But you did it anyway.
I was desperate.
And so, how did that, just in terms of logistically, how did that go? How did you pick up drugs? How did you deliver drugs? How did you sell drugs or make money off the sale of the drugs? How did that go?
They would tell me where to go pick it up and tell me where to take it.
And how did they get paid from your sale of drugs?
How did they get paid for myself?
How did they make money off that? Did you have to pay them before you got the drugs, or did they front them to you and then you pay them once they were sold? How did that go?
Most of the time I had to pay them.
Okay. So the first time you do it, when you're in a bad financial situation, that time, do they let you transport the drugs and get paid on the back end?
They did.
But after that, you have to front the money yourself. Is that what you're saying?
I would get the money from the customer and get it sometimes.
Okay. And so that goes on for, best guess, how long, where you're actually doing that for them voluntarily?
Maybe a month or so.
Okay. And you made a number of deliveries during that time and had customers that you could deliver to and all that?
That's correct.
Okay. At some point, once you'd made some money, did you decide you didn't want to do it anymore? Didn't want to deliver anymore?
Yes, sir. I didn't want to do it anymore. I was finally able to go back to work, and I didn't want to do it.
Okay. Did you tell the person that you had been communicating with that you didn't want to do that anymore?
I did.
Okay. Now, to be clear, at any point, was that the person you were afraid of? The
No,
person you've
not
been
at all.
communicating with all along?
Not at all.
Okay. Tell me about what ultimately made you afraid and why it made you afraid that you couldn't get out or that you couldn't stop at that time.
They were threatening my daughter.
How?
They went to my store and they took a picture of her at the store and sent it to me and told me how pretty she was and that she would make them a lot of money if I didn't make them money.
What else? Did you receive calls from these people?
They came to my house. They came to my work.
Was there ever a point where they parked outside your house in ski masks? Was your dad at your house when that happened?
Yes, my daddy seen them and my daughter seen them.
Did your dad move away?
He did.
Why didn't you feel like you could go to law enforcement about this at that time?
After I was arrested?
No, back while they're threatening you and you haven't been caught yet. Like, why didn't you go to law enforcement at that point?
Oh, because they weren't gonna hurt me or anything until they needed me to go do what they said, and I didn't. Then they would hurt me or hurt my daughter.
How often did they make it known to you during that period of time after you said you didn't want to do it anymore, that they were watching you or watching your family or following you? How often did they make that known?
Often, they would text me what color dress I had on, or my daughter and my grandson, what day she took him to work with her.
Now, since some of those threats, we'll jump ahead and then come back to where we are chronologically. We saw that law enforcement had some text communications on an app that they obtained shortly after you were arrested in this case. But ultimately, text messages themselves that showed these threats, like you don't have a string of text messages that are threatening you or anything like that. Is that correct?
And they always did the delete.
Explain how after you got arrested and everything, you had to get a new phone, like the iPhone. I'll explain that process, how that went.
I had to file on the insurance to get a new phone.
Because your phone had been seized and taken into
That's
evidence.
correct.
Okay. And in order to do the insurance claim, do they have to remotely turn off location services and delete?
They automatically, I guess, did that. Yes,
And delete whatever communications you had on the phone?
that's correct.
Okay. So eventually you get your old phone back from law enforcement once they've had a chance to search it, right?
Uh-huh.
And by that point, did you have those text messages still?
No, I did not.
Okay. So now you did explain to law enforcement kind of what had happened even back then when you got arrested, correct?
That's correct.
Okay. All right.
I actually took the new phone to them.
And so going back in time to where we were chronologically before I asked you about the phone. So, you indicated they're showing up, they're threatening you, they're talking about your daughter being human trafficked and all that. At some point, does it come time to do the delivery they want you to do?
Yes.
And so how does that go? How are you contacted? How are you notified? And what is supposed to happen?
And they sent me messages through, I think it was WhatsApp.
Okay. And are those messages from the people threatening you or from your contact or handler or whoever that guy is?
No, it was through the people that were threatening me.
Okay. So they tell you it's time to do the delivery at that point.
That's correct.
And so what do you do?
I went and got it and delivered it, and that's when I got in trouble.
So you have the drugs, you have the drugs, you're delivering it to wherever you're supposed to be delivering it to and get pulled over at that point.
That's correct.
Okay. Did you believe that you could safely go to law enforcement without them knowing about it and taking action to kill or seriously harm you or your family members
No,
prior to getting arrested?
no, because they were following me.
Now, after you get arrested, you cooperate with law enforcement to the extent you can and tell them what's going on. Why were you no longer afraid to cooperate and be truthful with law enforcement at that point, after your arrest?
After I was arrested, then it was up. I was no good to them anymore.
So you
I
can't
would
make them
I would be being watched by the police, obviously.
So as far as you understood at that point, you can't make them any more money. You're
Exactly.
burned. So they don't have any more interest in you.
Exactly.
I understand you got into the original arrangement of your own volition and committed crimes of your own volition. True?
Yes, sir, that's correct.
The drugs that you were caught with in this case, would you have been out of the conspiracy and not committing that crime, but for the fact that you truly believed yourself and your family's lives were in danger and they could potentially be taken if you didn't comply with what you were being ordered to do?
That's correct.
I have no further questions at this time.
Oh,
John?
Chief, you agree with me that
February of 2025, when you got caught by law enforcement, that you were bringing methamphetamine into the state of Florida,
It was-
correct?
It was March. But yes,
You got arrested on February 2nd, 2025.
no, sir. It was March 2nd. I know that for a fact because my store opens back up for our season on March 1st. That's why I would not have been doing that if I wasn't being forced.
So your testimony is in March 2025, you get arrested.
That's correct.
Okay. And on that date, you would agree with me that you were bringing methamphetamine from the state of Georgia to the state of Florida.
Yes,
Okay. And you brought a brick of methamphetamine, is what you told law enforcement that night.
yes, sir.
Almost 1,000 grams.
Yes, sir.
Now, let's talk a little bit about where you're coming from. You're coming from Conyers, Georgia,
That's where I live, sir.
and that's just outside Atlanta.
It's 20 miles east of Atlanta. Yes, sir.
And you would agree with me that there's probably a lot of law enforcement agencies in Atlanta, a lot of police officers.
That's correct.
And to get down here from that area, you drive through Columbus, Georgia.
It just depends on which way I drive, but yes, sir, I did that day.
Okay. Columbus is a fairly decent sized city. You'd agree with me, right?
Yes, sir.
Probably has quite a few law enforcement officers.
That's correct.
You drive through Phoenix City, Alabama.
Yes, sir.
Same thing. Law enforcement in Phoenix City.
Yes, sir.
What about Eufaula?
Yes, sir.
Dothan?
Yes, sir.
And then you get down here into the Panama City Beach area.
That's correct.
And you'd agree that you didn't stop anywhere in any of those cities to speak of law enforcement at all.
No, sir, they were following me.
You didn't call and tell anybody, call any law enforcement at any point and tell them, hey, this is going on?
No, sir, they would have hurt my daughter.
Okay. Your testimony today is that you're so afraid that your dad had to move and relocate.
He did.
What about you? Did you move and relocate?
Sir, my car was packed because that's what I was doing.
In fact, you're still living in Conyers today, aren't you?
I am back in Conyers now because I cannot be where I was because of my charges. My daughter's military.
You had some family in Hawaii. You testified today,
They
right?
moved back to Florida, sir.
But you could have moved to Hawaii.
How? I don't have the money to move to Hawaii on my own. I was staying on base with my daughter, sir.
My point is, though, you're still living in Conyers today, even though you're so afraid of these people up there.
Sir, I'm not afraid of them anymore. I'm not an asset to them. I can't make them money anymore.
So
They don't want anything to do with me now. They don't care.
your testimony is that, well, let's talk about why you were afraid. Your testimony today is that you were afraid that they were threatening to hurt your daughter in the future.
No.
Well,
When I refused,
have these people ever hurt your daughter?
have they hurt my daughter?
Yes.
Thankfully, no.
Have they ever hurt you?
Thankfully, no.
So they were threatening to hurt you at some point in the future.
If I didn't do what they said when they said it.
The night of March 3rd, when you drove down from Georgia, they were not actively doing anything to put you in danger. They were threatening to hurt you in the future.
They
Correct.
threatened me that they would hurt my daughter if I didn't do what they told me when that time came. And that's when they,
And at that time, you had a store in outside Atlanta and Conyers, correct?
no, my store's in Jonesboro.
Outside Atlanta?
Yes, it's south of Atlanta.
And that store makes you money?
Yes, sir, it
That
does. It's-
store actually made you pretty decent money, did it not?
Yes, sir, it did.
About $50,000 a month during March? April?
Yes, but then you have all winter that it makes absolutely nothing. Because all the lakes close from October 31st till March 1st.
Now, your testimony today is that you got these threats over the phone, over text. They sent you text messages.
They sent me text messages. They came to my house. They came to my shop.
And your testimony today is that you don't have these messages anymore because you had to get a new phone.
I don't have them because they got erased. Yeah, when
Because you
they,
had to get a new phone.
right.
Okay. You had to file an insurance claim to get a new phone?
Well, yes.
Why?
I didn't have
What
money
did you
to
tell
buy
them?
one.
What did you tell them the basis was for having to get a new phone?
I told them it was taken from my car, and it was.
Did you tell them who took it?
No, I sure didn't.
So you weren't honest with them about why you needed a new phone?
Well, someone did take it from my phone, from my car.
Okay. So your testimony today is you had to get a new phone, and then in order to do that, they had to wipe all your data.
I didn't know that was gonna happen.
That's what your testimony today is, right?
Yes,
When you were on the side of the road, did you show any of these threats to law enforcement?
and they didn't let me show them anything, sir. I
You
even
didn't-
asked them to call the
Did you
feds.
tell them, hey, I'm only doing this because that guy's following me?
No,
Did you tell them, hey, I'm only doing this because that guy over there is threatening my daughter?
no, I asked them to call the feds.
Did you tell them, hey, I'm only doing this because look at these messages I've got on my phone right here?
No,
Let's talk about the person that you were communicating with. What was that person's name?
I don't know his real name.
If I got the screens, please.
My
I'm
friend,
showing you what's been admitted evidence as states 4A.
okay.
And I think you just said it. He's in your contacts as my friend,
That's correct.
not big scary cartel guy.
That's not the same person.
Not these people are threatening me.
No, this guy's not the one that threatens me at all.
But your testimony today is that he's associated with that.
Well, I found that out later, sir.
Let's talk about some of these messages. Your Honor, permission to direct the council table.
Yes, you may.
Let's look at 4B. Ms. Heath, these messages, the green on the right side, these are the messages that you sent, correct?
Yes,
And on the left side, for the white messages, they are your friend that you're speaking to.
right.
So these messages here, you say, well, I am headed back to Florida tomorrow. I found it down there, was trying not to go anywhere else. My people can't wait any longer. Correct?
Mm-hmm.
And then he says, okay, what you're talking about drugs, getting drugs in these messages, aren't you?
Yes,
And
money.
when you say my people can't wait any longer, you're talking about the people you're going to sell the drugs to. Correct?
I'm really not sure.
Okay. And then you're accusing him of playing games with you and lying to you about picking up the drugs. Correct?
I think we were talking about money.
Okay. Well, let's go to the next
He would
one.
tell me he had,
So at the bottom of this message, it says, well, explain why, still nothing, correct?
right.
And let's look at the next photo. 4C, the top of it, still nothing. I need you to tell my people, this is the very next part of that conversation, correct?
Yes,
And the individual you're talking to sends you a nice photograph of a lot of methamphetamine, doesn't he?
yes, he does.
And your response is, well, why don't I have it yet? Does that sound to you like somebody who's scared and afraid?
That's not the same person, sir. That's not the person I was scared of.
Let's look at the next photo,
It's
4D.
it's more than one person.
4D. You're here talking, and you tell him you're in Florida. Correct?
That's correct.
And he says, okay, and you say, I will try to come back. I have a couple of good customers in Georgia. So you're in Florida and you decide to voluntarily go back to Georgia, where these people are. Correct?
That was before the threat started. That's when I was still voluntarily doing it.
Well, let's see here. Your next photograph, 4E. These messages, yeah, and I've been begging for a while. I was in Georgia. You didn't have anything for me. You really hurt my feelings. I've made you good money, given you money when you needed it. This is what I get in return. Sounds like you're the one angry with this guy and your suppliers, correct? You don't like the way they're treating you, correct?
No, because I couldn't get the money that they needed.
4F. I can't make nothing at this price. I would take 2 more right now, but it's not worth it if I don't make anything. I thought the stuff was gonna be way better for that price. Just the same old half-ass stuff. They ain't gonna pay that when they get better, cheaper. You're mad because your suppliers are giving you low quality for a high price. And you don't think you're gonna be able to go make any money off of it.
I
Aren't you?
couldn't make them the amount of money that they wanted.
Why are other people getting better prices? Makes me look like an idiot. You're upset because you're not able to make the money that you would like to make off of these transactions, aren't you? 4G. Yes, this will make me lose my biggest customer. He can get through Jake cheaper and better. You're afraid of losing your customers because of what your suppliers do, aren't you?
Yes. Then I can't give them the money that they needed.
So let's talk here, 4H. You're given an address to go pick up this substances, correct? 2203 Georgia 20, Conyers, Georgia. Correct?
Uh-huh.
Okay. And it turns out, your message here at the bottom says that is the city of Conyers Police Department. They sent you literally to the police, did they not?
Yes, they did.
And you didn't think, oh, that was a good time, maybe I should go say something. I'm literally at the police department.
What, while they're watching me?
Okay. And your response, really? Why would you give me the police address? 4J, why send me to the police department? 4K, okay, tell me why the police department? I'm scared, I ain't playing games, you send me to the police. Not once did you think to go into the police department and say, hey, look what's going on. Show them the threats?
No. They would hurt my daughter or me.
Your testimony is that you only did what you had to do because you're afraid of this future harm. And you're afraid to tell them no.
No, when they tell me to go pick something up, that is when.
And you were afraid to tell them no because you were afraid that they were going to harm your daughter sometime in the future.
Not sometime in the future. If I didn't do what they said when they said, they would hurt my daughter.
And that's why you were afraid to tell them no.
That's why I was a what?
Is that why you were afraid to tell them no, you weren't going to do this anymore?
I did tell them I wasn't going to do it anymore.
Okay. But you
My friend, but not the other people. It's 2 different people.
This photograph in 4L. They tried to get you to sell cocaine, didn't they?
Yes.
And you refused outright to do that, didn't you?
He was asking me to get.
So yes or no question. Did you refuse outright to sell cocaine? Yes or no?
For my friend? Yes.
Okay. So you agree to sell methamphetamine, but you're not too afraid to tell them no about cocaine.
It was 2 different people, sir.
Now, after you get arrested, did you tell law enforcement who these individuals are?
By the time I got out of jail, they were gone. I did try to help them and tell them.
Did you know information about them, names, phone numbers, ways to communicate with them?
The only numbers I had were in my phone, and I did not know anyone's real name. They make sure you don't know.
Fair to say that in the 1.5 years that you've been still living in Conyers, that they haven't kidnapped your daughter?
They haven't, because
They haven't threatened or
I'm of no use to them since I got arrested.
they haven't killed your family?
I don't associate with them anymore. I got arrested. I'm no good to them. Why would they threaten me now?
Well, I mean,
They disappeared.
any information that you can give on getting them arrested would not be helpful for them, would it?
How could I give any information? They disappeared. I tried to give you that information. I even brought my phone and I sat outside of the police department waiting on the investigator to come so I could open the box. And when I got
Objection,
my phone-
non-responsive, Your Honor.
Sustained.
Let's talk a little bit about how afraid you were of these people. So you're so afraid of these people that you agreed to move methamphetamine for them, correct?
Yes,
Okay. If they had asked you to go collect money from people, would you have gone to collect money?
I basically did.
Okay. If they had gone and asked you to go beat up somebody to collect money, would you go and beat up somebody?
If they were threatening me to,
If they had asked you to go burn somebody's house down, would you have done that?
if they threatened my daughter, yes, sir.
And would you have kidnapped somebody else's daughter if they had asked you to?
I couldn't hurt somebody.
Okay. And if they had asked you to go kill somebody, would you have done
I
that?
couldn't hurt somebody, sir. They wanted me to make them money.
Sorry, what was that?
They wanted me to make them money.
And you were also in this to make money, weren't you? That's why you did this.
To begin with, yes, sir.
And you continued to, and you got mad when your supplier was giving you low quality drugs and charging you more than other individuals, weren't you?
I couldn't. Can you repeat the question, please?
You got mad that your supplier was giving you low quality drugs and charging you more than they were charging other people because it was cutting into your profit margin.
It was cutting into their profit margin.
No further question, Your Honor.
You can redirect.
Yes, sir.
Just to be clear again, because law enforcement erroneously testified about the date of your arrest here, that won't be an issue since there's a charging document here which charges the correct date. I'm sure the jury will be instructed about that. But let's talk about your text messages that Mr. Sullivan was just asking you about here. The text messages where you're complaining about the price. Do you remember off the top of your head what day, what date those text messages were?
I don't.
Would it refresh your recollection if I showed you the date of those text messages?
Possibly.
May I approach, Your Honor?
May approach.
Let the record reflect I'm showing was admitted into evidence by the state as Exhibit 4D. What date were those text exchanges taking place on?
February 19th.
That was a couple of weeks before your arrest in this case on March 2nd,
That's
correct?
correct.
Same thing with state's Exhibit 4E. What date or two dates do those text messages cover?
February 20th, and
And the day before, correct?
it doesn't show it on there, but
It's going from Exhibit 4D to
yes,
4E. It's
yes,
two-
sir.
Basically, it's February 19th to February 20th, correct?
yes, sir.
Okay. So, and you've acknowledged you got into this to make money.
I did.
And the reason you wanted out was also because you weren't making the money that you thought you would make. Fair enough?
That's fair.
Okay. That wasn't the problem though, was it? I mean, yes, you wanted out because you're not making money, but that's when the circumstance changed. Is that right?
Sustained.
I'll rephrase. The reason is it true that the reason you became disillusioned and didn't want to do it anymore?
Objection waiting.
Sustained.
What is the reason you didn't want to sell drugs for them anymore?
Because my store was now making money.
Okay.
I could make a living without having to do it anymore.
So you don't even debate what the state was saying about wanting out because you're not making money or making money like you want to, correct?
Correct.
Is that why you told them, the cartel people, you wanted out? Or told your contact, whoever it was you told you wanted out, is that why you told them you wanted out?
I told them I wanted out.
And is that the reason why?
Yes.
Okay. Had you ever been threatened prior to telling them that you wanted out? And however exactly long it was before your arrest on March 2nd, a week or whatever it was, if they had not threatened you, threatened your family, would you have still been delivering drugs for them on March 2nd?
No, sir, not at all. My store opened on March 1st.
Now, once you got burnt and weren't useful to them anymore, you did try to cooperate with law enforcement, right?
Yes, sir, I did.
You had a meeting with them. You were there. Mr. Middleton was there. Law enforcement was there, and you tried to tell them what exactly was going on, correct?
I sure did.
You told them you were correct.
That's correct.
You weren't the only one scared, right?
No, I was not.
Is it true that law enforcement was so worried about cartel guys that they came to that meeting with you wearing ski masks themselves?
That's correct.
No further questions.
Any redirect? I mean, any cross?
No, Your Honor.
You may have a seat. Let you call your next witness.
At this time, the defense is arrested.
If you'll have a seat, ladies and gentlemen, we're going to take another break. We'll take a 10-minute break, start back at 20 after. I'm going to have some lunch brought in for y'all, okay? If everybody's ready to keep going there. Everybody ready to keep going? All right, I'll have some lunch brought in. All right, if you'll follow the bailiff from the back, leave your notepads in your seats. Take them on yourselves or with anyone else. This seat is back in the courtroom. Mr. Prince, is there something you want to address prior to bringing the jurors in?
Yeah, I'll just preserve it. Mr. Sullivan has prepared instructions that are in compliance with the controlling first BCA precedent and the conflicted circuits that resolved it doesn't appear. So the Fifth District Court of Appeals essentially says once the defense introduces a prima facie case of duress or necessity, the burden shifts back to the state. For the first DCA in Tyler, we state 131-7, third 811. That's the first DCA case from 2014. Says that the burden remains with the defense. That would be controlling, of course, in the absence of
Very good. All right. Are we ready to bring the jurors in?
yes, Your Honor.
Yes, sure. Bring them in.
Your Honor, since I hadn't, did I?
Yeah.
Your Honor, we haven't gotten to that point. I think I would like to call Investigator LaRoche for just one rebuttal question, two rebuttal questions. I don't know that it changed anything. If it's too late, I understand.
It's not too late, but I mean, gosh, almighty, y'all have.
I know. You already arrested in front of the jury? I arrested at the end of my case, but I don't know that.
I didn't ask for any rebuttal.
And that's
my fault. Tell me.
Hold on.
It's just gonna be one question.
All right, go ahead and bring them. You can go ahead and bring them in. Deputy Davis, go ahead and bring them in. Have a seat.
I apologize, Judge, it just dawned on me that.
All right, go ahead and have the juror call.
Jurors entering.
Get to your chair. Everyone else can have a seat. Did the state have a rebuttal witness?
Yes, Your Honor, I would like to recall Investigator LaRoche.
Investigator LaRoche, you're still under oath that you'll come and have a seat, speaking to the microphone. Mr. Sullivan, you may inquire.
Investigator LaRoche testified earlier today that you got a search warrant and located messages on Ms. Heath's phone.
That's correct.
During that process, did you ever locate any threatening messages?
No.
Rance, any questions?
Briefly. You captured those as screenshots, correct?
The pictures, I have a physical download on a USB of the entirety of the phone. And then the pictures that Mr. Sullivan presented are from my camera that I took. It's just easier to look at.
Right. And so the messages that we have pictures of, those aren't regular text messages. Those are messages between her and her handler or contact, for lack of a better expression, on some messaging app. Is that correct?
Yes.
Thank you for the question.
Anything else for the witness?
No, Your Honor.
You can have a seat. Mr. Sullivan, any other witnesses?
No further on.
Ladies and gentlemen, both the state and the defendant have now rested their case. The attorneys now present their final arguments. Please remember that what the attorneys say is not evidence or your instruction on the law. However, do listen closely to their arguments. They are intended to aid you in understanding the case. Each side will have equal time, but the state is entitled to divide this time between an opening argument and a rebuttal argument after the defense has given its closing argument. Mr. Sullivan, whenever you're ready.
Thank you. Ladies and gentlemen, as I told you this morning, this wasn't a very complex case. There's really no dispute as to the elements of this offense. The judge is going to tell you in just a few moments that I have to prove three things beyond a reasonable doubt. One, that Ms. Heath either brought into the state or possessed a substance. Two, that substance was methamphetamine. And three, the methamphetamine weighed more than 14 grams. You heard Ms. Heath, she testified basically to all of that today. That's not really why you're here and what you're to determine. I've proven beyond reasonable doubt those three things. What you're going to be asked to prove or to determine, though, is whether the defense has proven the defense of duress. Typically, in these trials, the burden is on the state to prove the charges beyond a reasonable doubt. And that is still the case in this particular case. But because the charges themselves are not really in dispute, we need to talk about the duress defense. Normally, and I think Mr. Middleton mentioned it during jury selection on Monday, the defense doesn't have to present anything. They don't have to present any evidence. But in this particular case, they have raised what's called an affirmative defense, which means the burden that is normally on the state to present evidence is actually on the defense to present evidence of their particular defense. And that's important because you're going to have to ask yourself, has the defense met their burden in this particular case? And the judge is going to read you all the instructions, and as part of the instructions on page 3 and 4, this is the instruction that deals with the duress defense. And I'm going to talk a little bit about this because I think it's important. The defense has to prove 8 things to you in order for you to find that the duress defense applies. They have to prove that the defendant reasonably believed an emergency existed. The defendant reasonably believed the emergency would cause death or serious bodily harm to herself or another. The perceived harm of death or serious bodily injury was imminent and impending. I think that's important. We're going to come back to that one and talk about in a minute. The defendant did not intentionally or recklessly place herself in a situation in which it was probable that she would be forced to choose the criminal conduct. Well, that's important because you heard her testimony today. She put herself in this situation by voluntarily getting herself involved with these individuals and voluntarily agreeing to sell narcotics for them. The defense can't show that she did not intentionally or recklessly place herself in that situation. Therefore, the duress defense doesn't apply. That in and of itself. The defendant had no reasonable means to avoid the emergency except by committing the trafficking of methamphetamine. You heard the testimony. She could have called the police. She could have gone to the police in Conyers, in Atlanta, in Columbus, Phoenix City, in Dothan. When she got down here, she could have called the cops. She testified that she had been working with them for several months, several weeks. She could have called law enforcement officers in any of the places that she went during that period of time. You saw the messages. She was actually even sent to the police department at one point. She had reasonable means to avoid this emergency. The trafficking of methamphetamine was committed out of duress to avoid the emergency. The perceived harm that the defendant avoided outweighed the harm caused by committing the trafficking of methamphetamine. And the defendant ceased her criminal conduct as soon as the necessity or apparent necessity for the criminal conduct ended. Now, I told you we were going to come back to talk about the imminent and impending. The judge will tell you that imminent and impending means the emergency is about to take place and cannot be avoided by using other means. Importantly, a threat of future harm is not sufficient for this defense to apply. So let's assume for a second that Miss Keith got these messages, these threats. Those threats would have been for future harm. And that's why one of these elements requires her to take reasonable means to avoid the emergency. Because when you have a threat of future harm, you have the ability to take measures to avoid that future harm without committing criminal crime. Any potential threat that Ms. Heath may have received or gotten was a threat for future harm. There was no impending and immediate emergency the night she drove from Georgia and brought this ginormous bag of methamphetamine to our community. Now, I told you, let's assume for a second she got those messages. The defense has the burden of proving this defense. What proof, what evidence have you seen that these messages ever took place? That these threats ever existed? You've not been presented any text messages? You've not been presented any photographs of that were allegedly taken of her daughter and sent to her? And I want you to ask yourself, why is that? Now, you heard the testimony that, oh, I couldn't get them because I had to get a new phone and they had to wipe my old one. They didn't have the old one to wipe. It was in the custody of law enforcement. And ask yourself, why? Why does that even make sense? Why would they have to wipe the old phone to get the new one? Anybody who has bought a new phone has gone and they've transferred things over. Verizon, AT&T, whatever carrier, they plug it in, they transfer things over, pull the phones back. You don't need to wipe the old one to give you a new phone. That doesn't make sense. What also doesn't make sense is when law enforcement got into the phone and looked at the messages between Miss Heath and this individual, there were no threats for Investigator Roach. The advantage that Miss Heath has is she's able to sit here through all the testimony. She can hear what everybody's saying, all the evidence that's presented. Investigator Roach, she's not able to. He has to sit out in the hallway. He can only testify when it's his turn. So he has no idea what Miss Heath testified to today. He told you that there's no threats when he looked at that phone. They're not there. At the end of the day, ladies and gentlemen, there's no evidence that these threats, this duress, existed outside Miss Heath's testimony. And your job is to determine whether she's credible or not, whether you believe her or not. And I submit to you that she is the only person in this case that has anything to lose. And the judge will tell you in a few moments that that's one thing you can use to determine credibility. If I got the screens, please. And when you are determining credibility, you have to ask yourself, well, what does she have to lose? What does she have to gain by telling us a story? What do the other witnesses have to lose or gain? This photograph is in evidence. I'm going to zoom in. I know they're probably hard to see. When I went through them earlier with Miss Heath, you may or may not be able to read them. You'll get copies to take back. They're a lot easier to read in the notebook. But I'll zoom in a little bit here so you can see. Because on redirect, Mr. Prince made a big deal out of when some of these messages were sent. You know, they're sent a couple weeks before. Well, you've got that date there, March 2nd. So you know the messages sent right before that were sent right before March 2nd. So 2 days before she ultimately gets arrested. And what is she talking about 2 days before she gets arrested? When you read those messages, ask yourself, do they sound like somebody who's afraid what she's doing? Or do they sound like somebody who's mad with her supplier, who's trying to make a buck? Mr. Prince asked her herself, why did you decide to get out of this? My store was making money now. That's all she was in this for. It was money. Simple as that. Ladies and gentlemen, the judge will tell you that if the state has proven its charges beyond a reasonable doubt, which I have in this case, your duty as jurors is to find the defendant guilty. And I ask you to do that in this case. Find the defendant guilty of trafficking methamphetamine more than 200 grams. Thank you.
I'm not going to spend a ton of time talking about it, but there is an issue that I want to talk about relative to the question of whether Ms. Heath actually possessed the substance that was tested and entered into evidence in this case. That's not going to be the main part of my argument, but I do want to discuss that with you. Before I get to that, though, I do think it's important that we kind of focus on what the analytical framework for addressing that question is. Because while it is true that the defense has to prove by a preponderance of the evidence that Ms. Heath acted under duress for that affirmative defense to apply, again, that's not the same standard that the state has to prove their case to. We just have to prove that it's more likely than not, essentially, that by the greater weight of the evidence that Ms. Heath did indeed act under duress at the time she committed the specific offense in this case. Okay, we don't have to prove that she acted under duress when she committed any other act or crime. It just pertains to the offense at issue in this case that occurred on March 2nd. That's the date of the offense. I know there was some confusion about February. It is March. That's the date charged in the information. The instructions will make that clear. But again, I do want to briefly kind of touch on what the framework for that analysis is before I get to the first element of the offense here. So a lot of times in a situation like this, the state will talk about it. It seems like a foregone conclusion that obviously, the most reasonable interpretation of the evidence by far is that the drugs that were tested are the drugs that were in the car. And that's a fine argument to make. But the question isn't like what seems most likely, what seems clearly and convincingly true. Those are other standards of evidence that don't apply in a criminal case. And the court will instruct you on what the standard of proof is in a criminal case. You're going to get a packet of instructions from the court, and you'll be able to take those instructions back with you into the jury room so that you can use them to guide your discussion as you're going through the process. And the court's going to instruct you first and foremost that the burden in this case is not to introduce the better or more believable or more convincing version of the events, but to exclude or eliminate every reasonable doubt. And here's what the instruction says. The defendant in this case has entered a plea of not guilty. This means you must believe or presume that the defendant is innocent. This presumption stays with the defendant as to each material allegation alleged in the information through each stage of the trial, unless it has been overcome by the evidence to the exclusion of and beyond a reasonable doubt. So that's the standard. Okay, that's the question ultimately that you have to answer about the elements of the offense before you get to the affirmative defense. And again, it's the state's exclusive burden to prove that. Okay, and I know it doesn't make sense yet why I'm saying or even talking about. I mean, we heard the evidence. Why are you acting like there's insufficient evidence potentially that she possessed the drugs that were tested? I'll get to that in a second and tell you why there is a doubt that comes from the evidence and from the lack of evidence here. But for purposes of our discussion here, it's important to remember that it is the state's exclusive burden. Also on page 5 of the instructions that the court will read you and then give you, they'll instruct you to overcome the state's presumption, to overcome the defendant's presumption of innocence, the state has the burden of proving the crime with which the defendant is charged was committed and that the defendant is the person who committed the crime. The defendant is not required to present evidence or prove anything. Again, on page 8 of those instructions, the court will likewise instruct you. The Constitution requires the state prove the accusations against the defendant. It's not necessary for the defendant to disprove anything, or is the defendant required to prove her innocence. It's up to the state to prove the defendant's guilt by evidence. And when we talk about like how high that burden is, exclusion means what it means in everyday life. Okay, like unless the court gives you a specific instruction or definition for a particular term in the jury instructions, it means what it means out there. So it doesn't mean like, obviously it's true that those are the same drugs, or clearly it's true that those are the same drugs. The standard here is exclusion, elimination of every single reasonable doubt. Now that term, reasonable doubt, that term is defined, and it doesn't mean exactly what you might think it means outside the courtroom. Outside the courtroom, I would submit if somebody says, "Oh, that sounds reasonable," what they're really saying is, that sounds like that's probably correct. It sounds like that's probably true. And that's how we all make decisions, right? Like we make the best decision that we can based on the information that we have available to us. But in here, reasonable doubt doesn't mean I believe that doubt to be true. Reasonable doubt doesn't mean probably. Reasonable doubt has a definition, and the court, as part of that definition, tells you what it's not, and he tells you where it comes from. This is again on page 5 of the instructions that the court will provide. The law does not require proof beyond all doubt on the part of the jury before a verdict is returned of guilty. A mere possible doubt, speculative doubt, imaginary or forced doubt is not a reasonable doubt. So that we know that's not a reasonable doubt. You know, if you're involved in conjecture or speculation, that's not a reasonable doubt. On the other hand, reasonable doubt as to the guilt of the defendant may arise from the evidence, the conflict in the evidence, or a lack of evidence. That's critical. That's how we know what a reasonable doubt is, because of where it comes from. If the doubt comes from the evidence, if the doubt comes from a lack of evidence, then it's a reasonable doubt. And now just because a reasonable doubt arises, that doesn't necessarily mean the defendant is automatically not guilty, but it does mean that the state then has to come forward with other evidence to eliminate or exclude the doubt that has arisen from the evidence, conflict in evidence, or lack of evidence. The way that I like to illustrate that point is to talk about a bank robbery. If the state has somebody that's being prosecuted for bank robbery, and they march in witnesses, and the witness says, "I was at the bank, I was a teller, that's the person that robbed me, I see him sitting right there." If they put on video surveillance footage and it shows, "Hey, that's the person that robbed the bank, looks like the same guy," and then the defense attorney gets up in closing argument and says, "Well, the state didn't introduce any evidence to indicate my client doesn't have an identical twin. How do we know he doesn't have an identical twin? Their evidence didn't prove that." That's speculative and imaginary. Not because I say so, but because of what the judge says. It's speculative and imaginary because it doesn't come from evidence, or a lack of evidence, or conflict in the evidence. It's totally speculative. That's why it's not a reasonable doubt. On the other hand, if the defendant in that bank robbery case took the stand or called a witness, and the testimony was, he's not a bank robber, but he does have an identical twin, and the identical twin's a bank robber, and the defendant had an alibi at the time, that could be true, it might not be true, but now a reasonable doubt has arisen because that evidence, that testimony is evidence. And again, it's not automatic that means not guilty. It just means that the state then has to come forward with other evidence which excludes that reasonable doubt. The other part that it's important before we get into argument to remind you of, I think, is that the state can't exclude reasonable doubt with argument, okay? Reasonable doubt, once it arises from the evidence, it has to be excluded by evidence, only evidence, not argument. Like you might think his argument's smart, you might think the argument's slick, might think he's probably right, but that's not evidence. And you can't exclude reasonable doubt with argument. Again, that's not me telling you that, that's what the instructions say. Going back to page 5 again, the presumption stays with the defendant as to each material allegation in the information through each stage of the trial, unless it's been overcome by the evidence to the exclusion of and beyond a reasonable doubt. Further back in the jury instructions, where the court lists the rules for deliberation, the court will instruct you, this case must be decided only upon the evidence that you have heard from the testimony of the witnesses and have seen in the form of exhibits in evidence, and on these instructions, on the evidence and the law, not on argument. What the attorneys say, while intended to aid you in your analysis, is not evidence and cannot be the basis of an argument that like reasonable doubt has been excluded. Reasonable doubt can only be excluded by the evidence. And it's important to remember as you go through this analysis and do the job that you've taken an oath to do here, that we trust you to do this because this is the only way to ensure that the process is going to work. If the process fails for some reason, fellow citizens are supposed to be the ones that follow the law. You guys don't have an interest in anything happening here except that you have an interest in a just system. And so that's why it's so critical and important that you follow the law, and the court will remind you of how important that is himself as well. On the instructions that you'll receive here, the court will instruct you. You must follow the law as it is set out in these instructions. If you fail to follow the law, your verdict will be a miscarriage of justice. There is no reason for failing to follow the law in this case. All of us are depending on you to make a wise and legal decision in this matter. And the last thing he'll tell you before he sends you out, in closing, let me remind you that it is important that you follow the law as spelled out in these instructions in deciding your verdict. There are no other laws that apply to this case. Even if you do not like the laws that must be applied, you must use them. For 2 centuries, we have lived by the Constitution and the law, and no juror has the right to violate the rules we all share. What does that mean? And why does the court instruct you that way? Because it's not natural to decide anything based on exclusion. Now, I got 3 little boys, and they're all terrors, and we always go to Michigan for Christmas time. And a few years ago, you know, we're all upstairs, and we hear them playing downstairs, and all of a sudden, I go downstairs, and this 85-inch TV is shattered. I don't sit my youngest down and turn to the other 2 and say, all right, you don't have to prove or disprove anything. You don't have to introduce any evidence. You 2, exclude every single doubt, every reasonable doubt about whether youngest here broke the TV. That's not how we think. That's not how we make decisions. But it is how you have to make decisions in here. You can't just say, my gut says this. You can't just say, it's probably this. That's not the oath that you took. The oath you took is to hold the state to the requirement to exclude every reasonable doubt. So regarding the elements of the offense here, I do want to, at least briefly, and spend a little bit of time talking about where I think a reasonable doubt arises and where you should consider a reasonable doubt having arisen from the evidence in this case. Again, the state does have to prove that the substance was methamphetamine. That's the second element of the offense. The substance, not some substance she possessed previously, not some substance that she believed was present. They got to prove that bag that was tested was the bag she had. That's what they have to prove beyond into the exclusion of every reasonable doubt. And there is at least some reason to question that. And I'm not going to sit here and say that it's probably not the same dope. It probably is the same dope. I can say that because probably is not the standard. But there was testimony and conflicts in the testimony, which did give me a question about this. And the reason I say that is, when I was questioning the detective, I asked him about a weight discrepancy. I asked him about the fact that the narrative report that he had indicated that the weight of the drugs in the box aggregate was 1,286 grams. I pointed him to another section that showed that the weight was 1,253 grams. My purpose in doing that was not so much to focus on that weight discrepancy, because he was saying, like, regardless of what the weight was, it came out of that area and that ultimately was tested. But it's not insane to think, because it has happened, and does occasionally happen at least, that the wrong exhibits can be sent under the wrong number. And I would submit that there's evidence that supports that conclusion in this case. And the reason that I say that is, and I was very specific to ask him this, and I asked him it twice. And if you don't remember this, and you probably don't, there was no reason that it would have stuck out as significant at the time, but I did ask the detective twice, what was the item number of that exhibit, that agency number, that item number for that drug that you tested, that you sent to FDLE, what item number? It was item number 1, agency exhibit number 1. I know you don't have notes about that. I know you probably don't remember that, but you can ask for a readback. If you don't remember that, you can ask, once you go back to deliberate, if you want to know, you can ask the court reporter to read those portions of the testimony back to you. You come out here, the judge will have her do that, and she'll read it back to you. That was agency exhibit or item number 1. What item did FDLE tell you that they tested? They said it was item number 3.
Your Honor, may we approach?
Yes, sir.
Thank you, Your Honor. Y'all heard what the evidence was. What I say the evidence is in the evidence. What he says the evidence is in the evidence. The law is in black and white, and you took an oath to follow it. Moving on then, talk about duress. The state's right, we do have the burden to prove the elements of duress. It's by the preponderance test, greater weight of the evidence. Okay, that doesn't mean we have to exclude every reasonable doubt. Doesn't mean that it's got to be clear and convincing that all of these elements are present. So I want to talk about what those elements are. Number 1 is the defendant reasonably believed an emergency existed. And the state wants to make the argument that there's no evidence that that's true. Well, there is evidence that that's true. First of all, she told you that. And you're allowed to consider the factors under weighing the evidence that the court will instruct you about. Did she seem to have an accurate memory about that? Yes, I would submit that she did. Did she seem honest and straightforward in her testimony about that? Did that seem, let me just pose the rhetorical question. Did that seem like feigned emotion when she was talking about the threat to you? Did she seem like she was up here acting to get a benefit? And if she was going to lie, why would she admit that she got into this herself? That creates a problem for her under the element that says the defendant didn't intentionally or recklessly create the situation or put herself in the situation. We'll talk more about that element in a few minutes. But I'm just making the point, if she's going to lie, why say you put yourself in this voluntarily? Why wouldn't she just say, I went to pick up money for this guy. Next thing I know, they tell me I have to deliver drugs or they're going to kill my daughter. If you're going to lie, that's the lie you tell. That's not what she said. She told you honestly, she got involved because she wanted to make money. She knew it was a crime. She did it anyway. And why do you think she's charged with trafficking on March 2nd and not conspiracy for a greater amount? Because she proffered to law enforcement as she told you she did.
That's not an evidence.
Sustained.
You heard testimony that there was a meeting between the defendant, Mr. Middleton was there, she went there, and she told them she was threatened. She told you that's what happened at that meeting. Don't you think if it weren't true, by the way, that law enforcement also took this seriously and was also afraid, and it wasn't true that they were wearing ski masks? Don't you think in rebuttal, the detective would have told you that? They were scared too. That's why they're wearing masks like they're in a movie. Folks, you should take that testimony and consider it as corroborative, strong evidence that there was really something to be afraid of here. And if the state wants to argue that there was nothing in the phone that could be interpreted as a threat, look, he's looking at the messages in the app. That's what the pictures you have are. That's what he's looking at. If he looked at text messages, he wouldn't necessarily know that that specific picture of her daughter was intended to be a threat. Either way, it's not before you. He said they took a digital copy to the phone. Okay, if you got a digital copy of the phone, introduce it as an exhibit and let you guys decide if there's something in it that's threatening. You don't just get to state in conclusory fashion without even offering that you've looked at the actual text messages that there's nothing threatening. Of course, you didn't see anything threatening, right? He didn't go through and ask her specifically, what's the threat? What's the threat? That's not the testimony. That's not the evidence. She told you that she told them that she was threatened. She told you, and you heard, that there was a meeting at which Mr. Middleton was there and they were there, and she conveyed that to them. If that weren't true, the detective would have told you there was no meeting. That wasn't true. We didn't come in ski masks. He would have told you that, but that evidence is not before you. I would submit, by the greater weight of the evidence, we have established that there was a real emergency. The second element of duress is the defendant reasonably believed the emergency would cause death or serious bodily harm to herself or another. This is pretty much inextricably intertwined and linked with the first element. If there is a real threat, then obviously, since the threat is to cause death or harm to her or a family member, then number 2 is proven as well. Number 3 is the perceived harm of death or serious bodily injury was imminent and impending. And that term is that phrase is defined. So let's go down and look at how the court has instructed you regarding the definition of imminent and impending. Imminent and impending means the emergency is about to take place and cannot be avoided by using other means. A threat of future harm is not sufficient for this defense to apply. Okay, so it doesn't mean at this exact instant. If death is impending, you're not already dead. right? Every single threat that's ever been made in the history of the universe is by its very nature about something that's going to take place in the future. What the court has instructed you is that it has to be in the very near future. That's what impending instead of already happened or happening right this second means. Impending refers to the future. So look, this doesn't take a rocket scientist to understand what the law is attempting to get you to understand about imminent and impending. It can't be 6 years from now. So like if the threat had been, you know, at some point in the future, we may do something wrong for you, wrong to you, may do something wrong to your family, but they haven't asked her to deliver drugs yet, then the threat's not imminent and impending yet. The reason that the threat was imminent and impending in this case, that the emergency was imminent and impending, was because one, it's a threat of an ongoing nature. And the threat didn't become right until she was given the instruction to do the thing that the threat pertained to. Once they told her, now's the time for you to deliver, now the threat's real. Now it's imminent and impending. Now her daughter's in danger, now she's in danger. That's what imminent and impending means. Not some vague future threat, some threat that's gonna happen in the near future now because the orders have been given. And if I violate those orders, something bad is gonna happen to my daughter, to me, or to all of us. The fourth element, the defendant did not intentionally or recklessly place herself in a situation in which it was probable that she would be forced to choose criminal conduct. For folks that don't get involved in criminal conduct, it might seem like any engagement with criminals is likely to produce a situation where you're going to have to commit other crimes. But that's not necessarily the case. Right? Not all criminals are created equal. I mean, do you think law enforcement walks around everywhere they go with masks on? No, because not all criminals are created equal. Certain criminals present a much greater and more grave risk to people. And Miss Heath told you she didn't know she was getting involved with cartel guys when she first got involved in this. The guy that she's texting with is not the guy she's afraid of. The guy that she's communicating with isn't the guy that she's afraid of. She's afraid of the people who are supplying him. She's afraid of the people who show up at her shop. She's afraid of the people that send her pictures of her daughter. That's who she's afraid of. And that's not the person or people that she was interacting with when she made the decision to get in the first place. Was it stupid to get involved in this? Yes. Was it illegal to get involved with these people and agree to deliver drugs? Yes. But not every drug dealer who slings dope or carries dope for other distributors higher up the chain gets in trouble with the cartel. That's not how that normally goes. This is a unique situation. That's why law enforcement acted uniquely when they took or conducted the meeting with Ms. Heath in this case. The next thing that the court instructs you about is that number 5, the defendant had no reasonable means to avoid the emergency except by committing trafficking in methamphetamine. And the state keeps making the point, well, you could have stopped this law enforcement agency, you could have stopped in this town, you could have stopped in this town. And what is that little town going to do for her daughter wherever she is? What are they going to do for her? Like, can she call law enforcement? Sure, she can. But if she's being followed and her daughter's being followed, and is law enforcement going to stay with them 24 hours a day and babysit them? No, of course not. She didn't believe that would be the case, and she shouldn't believe that would be the case. This was a real threat from real criminals, and she had no reason to believe that law enforcement would be able to protect her when they still wanted something from her. And that's a critical point too. You know, because anytime I look at duress, the question that I always ask myself is like, okay, so you try to cooperate after the fact and you're willing to say all this stuff now. What's different about now? Like, if you can talk about this now, why couldn't you talk about it back then? But she answered that question on her own to Mr. Sullivan on cross. Back then they needed her. They wanted something from her. She was an asset that they were using to make money. Once she's burned, she ain't anything to them. They don't need her anymore. It's on to the next one. That's the difference. The reason she couldn't go to law enforcement before was because she was still their asset, she was still their property, and they were not done using her. And if she had tried to prevent them from using her, from using her to make money, then the cartel members very well may have carried out the threats that they made against her and her family. I would submit that element has been proven as well. Number 6, the trafficking methamphetamine was committed out of duress so as to avoid the emergency. Well, that's how she avoids them hurting her family. The thing that she did that made them start threatening her was say, I don't want to deliver for you anymore. That's what the threat's related to. So number 6 is proven. Number 7 is that the perceived harm that the defendant avoided outweighed harm caused by committing trafficking in methamphetamine. Look, if the threat is your daughter's going to be sold into human trafficking, or you take drugs to people that already want it and would get it from somebody else, even if you weren't doing it, I would submit that the harm threatened against her and her family was far greater than delivering drugs. And then number 8, the defendant ceased her criminal conduct as soon as the necessity or apparent necessity for the criminal conduct ended. Don't you think law enforcement would have told you if she was still slinging dope? I mean, they know that. They investigate. They have CIs. Like, that's how law enforcement works, especially on drug cases. That's not the evidence. Her testimony was she stopped that day because she was burned, useless to them at that point. And since then, she hasn't done it. She did make it. At the end of the day, like, I'm not standing here arguing she's innocent in this. But did she intentionally cause this harm? I don't even think the state's going to argue that. Did she recklessly? It was stupid. It was negligent. But is it like you're just abandoning all common sense altogether? Again, levels of criminality. You know, a DUI is not the same thing as murder, right? There's levels of criminality, levels of stupidity. If we're talking about reckless, you at least have to have the predicate knowledge of facts that would make you think, I'm going to be threatened. My family's going to be threatened. She thinks she's just involved in some low-level dope slinging. She doesn't know that the people controlling this network is the cartel. That's why she didn't knowingly or recklessly create this situation. It's a higher standard than accidentally. It's a higher standard than stupid. And at the end of the day, like I said, what this case really comes down to, because the defense has the burden of proof, is just evaluate her testimony. Like, you use all those factors that the court gave you, but use your own eyes. Like, at the end of the day, you get to decide if you believed what she told you. Like, I wouldn't be standing here asking this question, did she seem like she was being honest? If it didn't seem like she was being honest, the reason I'm saying decide the defense on that basis is because she comes off as credible. She comes off as truthful. And I think that the fact that I would submit that the fact that law enforcement corroborated that fear by wearing those masks at that meeting is the best evidence you can have outside of what she said about what was going on before her arrest. If those professionals see the danger, y'all should see the danger too and find her not guilty.
Oh, thank you, Your Honor. Talk about this alleged meeting. No evidence that this meeting even took place. No evidence if it did take place, who was there, where it was. We have no evidence that any of that even existed. Mr. Prince wants you to put so much stock in this meeting and law enforcement wearing masks, and all you've got is Ms. Heath's testimony that this happened. You've got no evidence about it. You've not seen or heard any evidence about it. Mr. Prince made a comment about, why wasn't the investigator re-asked that question? Even if it did happen, you have no evidence whether he was even involved or not, whether he could even testify to what happened at that meeting, if it even happened. And I think that's important, because one thing that Mr. Prince told you is that the state can't, give you this information in a conclusory fashion when he was talking about the phone and whether there were threats in the phone or not. He said that Investigator Loach's testimony concluding that there were no threats in that is not sufficient. But that's exactly everything that the defense wants you to believe, are conclusory statements without any proof or evidence whatsoever. This whole duress defense is a conclusory assumption that they want you to jump on. He wants you Mr. Prince made the argument that the phone's in evidence and you could have seen the whole phone. Well, the way that these trials work, these criminal prosecutions work, is none of this is a surprise. All the evidence that I have has to be turned over to the defense. They have time to look at it and review it. And he's got the ability to present any evidence that he thinks is necessary or sufficient. And in this particular case, because the defense has raised an affirmative defense, he has the burden to present evidence of that defense. And I submit to you that if there were threats and evidence, or evidence of these threats, that he equally could have shown those to you. The simple fact is there's been no evidence presented in this trial that Ms. Heath was ever threatened other than her own conclusory statements. And that's important because Mr. Prince mentioned that, why would I be up here arguing does she seem credible? And does she seem credible is one factor that you can use to determine whether she actually is being credible and truthful. But another thing that you should consider is, does the witness's testimony that's given in court agree with the other evidence in the case? And I submit to you that Ms. Heath's testimony on the stand does not agree with the other facts and evidence. And I'm going to go through some of that in a moment, but I'm going to tie it in with one thing that Mr. Prince said. He said, why would she admit to getting into this voluntarily? Why would she admit to putting herself into this situation? Well, the simple fact is that you deny what you can and you admit what you have to. And when you look at the other evidence in this case and compare it to whether her testimony agrees with the other evidence, she had to admit that. You can see those text messages. Not quick, if I can have the screens, please. You can see in these messages where she's talking about the prices and asking her supplier, you're lying to me, you're playing with me, I've been begging you. She has to admit that. She can't deny it. It's clear nobody would ever believe her if she denied that. Does her testimony agree with the other evidence? Well, you heard her testimony that I found out these were cartel, I got scared and I tried to stop. Well, you've got the message from 2 days before she gets arrested, complaining about the supply. You heard her testimony that she's so scared because these people showed up to her work and took pictures of her daughter. Yet she continues to work and live in the same exact locations. Is that consistent with somebody who's afraid of these imaginary boogeymen? Mr. Prince mentioned the definition of imminent and impending, and I submit to you, you can use your common sense on what those mean. The judge will give you that definition, and like we both said, he will tell you that a threat of future harm is not sufficient for this defense to apply. And the simple fact of the matter is that the defense has failed to prove 3 of these 8 elements, at least, that the perceived harm of death or serious bodily injury was imminent or impending, that the defendant did not intentionally or recklessly place herself in a situation in which it was probable that she would be forced to choose a criminal conduct, that the defendant had no reasonable means to avoid the emergency except by committing the trafficking of methamphetamine. Because the defense has failed to prove those 3 things, your duty as jurors is to find the defendant guilty of trafficking. Now, Mr. Prince briefly mentioned that there was some reasonable doubt as to the elements. I don't think that there's any doubt that this bag of methamphetamine weighs more than 14 grams. You heard that testimony. I don't think you have any doubt that this substance, in fact, is methamphetamine. You heard that testimony. Mr. Prince alluded to some doubt that maybe this bag didn't come out of Miss Heath's vehicle and she didn't possess this bag that night. Again, let's look at the evidence. You saw the photos. It was the photo of the methamphetamine that came out of that bag or that box. And you can see the bagging is still in here. That's the bag on the left side of this photograph. You heard the testimony that this bag was collected from Miss Heath's vehicle, submitted to the Florida Department of Law Enforcement, and tested. Now, Mr. Prince made some questions, made some argument as to the discrepancy in the weights, but you also heard the testimony that the weights, the 1,200 amount that was given by law enforcement was the weight of the total package, including all of the baggies and everything that the methamphetamine was in, while the FDA analyst takes the methamphetamine out of those packages and weighs solely the methamphetamine. That's why there's the discrepancy between 1,200 grams and 984. There is no doubt in this case that this defendant committed this crime. And there's no doubt that when she did so, she was not under duress. And you don't have to take my word for it. Because like I said, does a witness's testimony today match the other evidence in the case? And I submit to you that Ms. Heath, he told you exactly why she was doing this the night she got arrested.
My name's Sergeant Head. I just want to, you do my hand? Yeah. Super cooperative, very nice. Just been trying to pay my bills. Look, EJ, what do you got in the car? Yeah. Do you have a camera? That's good.
Just trying to pay my bills. That's what this was all about. And I get it. Times are tough. Everyone feels it at the gas pump, the grocery store. We're all going through that. But to prey on our community and to prey on people who suffer from addiction, to bring this poison to our streets, there were other ways Ms. Heath could have chosen to pay her bills. She chose to go this route. You heard her testimony. Several months a year, her business does $50,000, $60,000 a month. That's more than a lot of people make in a year. She chose to prioritize making money over following the law. I ask you to find the defendant guilty as charged. Thank you.
Members of the jury, thank you for your attention during this trial. Please pay attention to the instructions I'm about to give you. You'll get these instructions sent back with you. Christina Heath, the defendant in this case, has been accused of the crime of trafficking methamphetamine. Certain drugs and chemical substances are by law known as controlled substances. Methamphetamine is a controlled substance. To prove the crime of trafficking in methamphetamine, the state must prove the following three elements beyond a reasonable doubt. Christina Heath knowingly possessed or brought into Florida a substance. The substance was methamphetamine. The methamphetamine weighed 14 grams or more. To prove Christina Heath knowingly possessed a substance, the state must prove beyond a reasonable doubt that she knew of the existence of the substance and intentionally exercised control over that substance. Control can be exercised over a substance, whether the substance is carried on a person, near a person, or in a completely separate location. Mere proximity to a substance does not establish that the person intentionally exercised control over the substance in the absence of additional evidence. Control can be established by proof that Christina Heath had direct personal power to control the substance with the present ability to direct this control by another. If you find the defendant guilty of trafficking in methamphetamine, you must further determine by your verdict whether the state has further proved beyond a reasonable doubt that the methamphetamine weighed 14 grams or more, but less than 28 grams. The methamphetamine weighed 28 grams or more, but less than 200 grams. The methamphetamine weighed 200 grams or more. An issue in this case is whether Christina Heath acted out of duress in committing the crime of trafficking methamphetamine. It is a defense to the crime of trafficking methamphetamine if the defendant acted out of duress. To find the defendant committed trafficking methamphetamine out of duress, you must find the following 8 elements. The defendant reasonably believed an emergency existed. The defendant reasonably believed the emergency would cause death or serious bodily harm to herself or to another. The perceived harm of death or serious bodily injury was imminent and impending. The defendant did not intentionally or recklessly place herself in a situation in which it was probable that she would be forced to choose the criminal conduct. The defendant had no reasonable means to avoid the emergency except by committing the trafficking methamphetamine. The trafficking methamphetamine was committed out of duress to avoid the emergency. The perceived harm that the defendant avoided outweighed the harm caused by committing the trafficking methamphetamine. The defendant ceased her criminal conduct as soon as the necessity or apparent necessity for the criminal conduct ended. Imminent and impending means the emergency is about to take place and cannot be avoided by using other means. A threat of future harm is not sufficient for this defense to apply. The reasonableness of the defendant's belief that an emergency existed should be examined in the light of all the evidence. In deciding whether it was necessary for the defendant to commit the trafficking methamphetamine, you must judge the defendant by the circumstances by which he was surrounded at the time the crime was committed. The emergency facing the defendant need not have been actual. However, to justify the commission of the trafficking methamphetamine, the appearance of the emergency must have been so real that a reasonably cautious and prudent person under the same circumstances would have believed the emergency could be avoided only by committing the trafficking methamphetamine. Furthermore, the defendant must have actually believed the emergency was real. The defendant must prove the affirmative defense of duress by the preponderance of the evidence. The defendant has entered a plea of not guilty. This means you must presume, believe the defendant is innocent. The presumption stays with the defendant as to each material allegation and information through each stage of the trial, unless it has been overcome by the evidence to the exclusion of and beyond a reasonable doubt. To overcome the defendant's presumption of innocence, the state has the burden of proving the crime with which the defendant is charged was committed, and the defendant is the person who committed the crime. The defendant is not required to present evidence or prove anything. The law does not require proof beyond all doubt on the part of a jury before it returns a verdict of guilty. A mere possible speculative, imaginary, or forced doubt is not a reasonable doubt. A reasonable doubt is not a guess or mere conjecture. Rather, it is a doubt based upon reasoning and common sense after careful and impartial consideration of all the evidence in the case. A reasonable doubt as to the guilt of the defendant may arise from the evidence, conflict in the evidence, or the lack of evidence. If, after careful and impartial consideration of all the evidence, you have a reasonable doubt as to the guilt of the accused, it is your duty to find the defendant not guilty. On the other hand, if, after careful and impartial consideration of all the evidence, you are convinced beyond a reasonable doubt that the defendant is guilty, it is your duty to find the defendant guilty. It is to the evidence introduced in this trial and to it alone that you look for that proof. It is up to you to decide what evidence is reliable. You should use your common sense in deciding which is the best evidence and which evidence should not be relied upon in considering your verdict. You may find some of the evidence not reliable or less reliable than other evidence. You should consider how the witnesses acted as well as what they said. Some things you should consider are, did the witness seem to have an opportunity to see and know the things about which the witness testified? Did the witness seem to have an accurate memory? Was the witness honest and straightforward in answering the attorney's questions? Did the witness have some interest in how the case should be decided? Does the witness's testimony agree with the other testimony and other evidence of the case? Whether the state has met its burden of proof does not depend upon the number of witnesses that is called or upon the number of exhibits that is offered, but instead upon the nature and quality of the evidence presented. The fact that a witness is employed in law enforcement does not mean that his or her testimony deserves more or less consideration than that of other witnesses. Expert witnesses are like other witnesses, with one exception. The law permits an expert witness to give her opinion. However, an expert's opinion is reliable only when given on a subject about which you believe her to be an expert. Like other witnesses, you may believe or disbelieve all or any part of an expert's testimony. It is entirely proper for a lawyer to talk to a witness about what testimony the witness would give if called to the courtroom. The witness should not be discredited by talking to a lawyer about his or her testimony. You may rely upon your own conclusion about the credibility of any witness. The juror may believe or disbelieve all or any part of the evidence or the testimony of any witness. The defendant in this case has become a witness. You should apply the same rules to the consideration of her testimony that you apply to the testimony of other witnesses. The Constitution requires the state to prove its accusations against the defendant. It is not necessary for the defendant to disprove anything, nor is the defendant required to prove her innocence. It is up to the state to prove the defendant's guilt by evidence. These are some general rules that apply to your discussion. You must follow these rules in order to return a lawful verdict. You must follow the law as is set out in these instructions. If you fail to follow the law, your verdict will be a miscarriage of justice. There is no reason for failing to follow the law in this case. All of us are dependent upon you to make a wise and legal decision in this matter. This case must be decided only on the evidence that you've heard from the testimony of the witnesses and have seen the form of the exhibits and evidence and these instructions. This case must not be decided for or against anyone because you feel sorry for anyone or are angry at anyone. Remember, the lawyers are not on trial. Your feelings about them should not influence your decision in this case. Your duty is to determine if the defendant has been proven guilty or not in accord with the law. It is the judge's job to determine a proper sentence if the defendant is found guilty. Whatever verdict you render must be unanimous. That is, each of you must agree to the same verdict. Your verdict should not be influenced by feelings of prejudice, bias, or sympathy. Your verdict must be based on the evidence and on the law contained in these instructions. Deciding a verdict is exclusively your job. I cannot participate in that decision in any way. Please disregard anything I may have said or done that makes you think I preferred one verdict over another. You may find the defendant guilty as charged in the information or not guilty. If you return a verdict of guilty, it should be for the highest offense which has been proven beyond a reasonable doubt. If you find that no offense has been proven beyond a reasonable doubt, then of course your verdict must be not guilty. The verdict must be unanimous. That is, all of you must agree to the same verdict. Only one verdict may be returned as to the crime charged. The verdict must be in writing, and for your convenience, necessary has been prepared for you. It is as follows. Verdict. We, the jury, find as to the defendant, Christina Heath, as follows. Check only one. The defendant is guilty as charged of trafficking methamphetamine. The defendant is not guilty. Special findings. Check only one. If you find the defendant guilty of trafficking methamphetamine, you must further choose one of the following. We find that the methamphetamine weighed 200 grams or more. We find the methamphetamine weighed 28 grams or more, but less than 200 grams. We find the methamphetamine weighed 14 grams or more, but less than 28 grams. In just a few moments, you will be taken to the jury room by the bailiff. The first thing you should do is elect a foreperson who will preside over your deliberations. The foreperson should see to it your discussions are carried on in an organized way and that everyone has a fair chance to be heard. It is also the foreperson's job to sign the date the verdict form when all of you have agreed on a verdict and to bring the verdict form back to the courtroom when you return. During deliberation, jurors must communicate about the case only with one another and only when all jurors are present in the jury room. If a juror goes to the restroom, the deliberation should stop until the juror returns. You are not to communicate with any person outside the jury about this case. Till you've reached a verdict, you must not talk about this case in person or through the telephone, writing, or electronic communication, such as a blog, Twitter, email, text message, or any other means. Do not contact anyone to assist you during deliberations. These communication rules apply until I discharge you at the end of the case. If you become aware of any violation of these instructions or any other instructions I've given in this case, you must tell me by giving a note to the bailiff. Many of you have cell phones, tablets, laptops, smartwatches, and other electronic devices here in the courtroom. The rules do not allow you to bring your phones or any of those types of electronic devices into the jury room. Kindly leave those devices on your seats where they will be guarded by the bailiff while you deliberate. They will be secure. If you need to communicate with me, send a note to the bailiff signed by the foreperson. If you have voted, do not disclose the actual vote in the note. If you have questions, I will talk to the attorneys before I answer, so it may take some time. You may continue your deliberations while you wait for my answer. I will answer any questions, if I can, in writing or orally here in open court. During the trial, items will receive into evidence as exhibits. You may examine whatever exhibits you think will help in your deliberations. The exhibits will be sent into the jury room with you when you begin to deliberate. In closing, let me remind you that it is important that you follow the law spelled out of these instructions in deciding your verdict. There are no other laws that apply to this case. Even if you do not like the laws that must be applied, you must use them. For 2 centuries, we have lived by the Constitution and the law. No juror has a right to violate the rules we all share. Mr. Sullivan and Mr. Prince, those actually reflect the instructions agreed upon by the parties?
Yes, sir.
All right, ladies and gentlemen, in just a moment, Deputy Dexter is going to take you back to the jury room. Mr. Causley, you are our alternate juror. So you will not go back to deliberate. I only need 6 jurors, but I pick all these juries on Monday. I have run out of jurors by the time I got to Thursday and Friday, even with alternates. I let the rest of you know that because I've sent a jury back in the back and they didn't deliberate because they were waiting for the other juror to get there. So Mr. Causley will not be going back. So you can go ahead and elect a foreperson. Deputy Hines, I'm sorry, Have changed up. It's Deputy Hines and not Deputy Deck. But, we'll follow him back and go ahead and start, Mr. Carter, if you just remain in the courtroom. Counsel, thank you for a well-tried case. We'll be in recess until we hear from the jurors. Mr. Miller, let's go ahead and get her in here, okay? All right, Ms. Heath and Mr. Prince, Mr. Milton, Mr. Sullivan, we're all present. Deputy Dexter, from understand the jurors have reached a verdict.
Yes.
Let's bring them in. All the jurors are present. Everyone can have a seat. Are you the foreperson?
Yes, sir.
I understand the jurors have reached a verdict. Is that correct?
We have.
You'll hand the verdict form to Deputy Dexter. All right. It's Ms. Heath, Mr. Prince, and Mr. Milton. If you'll all have, stand, please. Madam Clerk, if you'll publish the verdict.
Yes, verdict. We, the jury, find as the defendant Christina Heath as follows. The defendant is guilty as charged of trafficking methamphetamine. Special findings. If you find the defendant guilty of trafficking methamphetamine, you must further choose one of the following. We find the methamphetamine weighed 200 grams or more. So say we all, dated the 6th day of August, 2026, foreperson, James Conway.
You can have a seat. Madam Clerk, if you'll poll the jurors, please. Ladies and gentlemen, I wish to thank you for your time and consideration of this case. I also wish to advise you some very special privileges enjoyed by jurors. No juror can ever be required to talk about the discussions that occurred in the jury room except by court order. For many centuries, our society has relied upon juries for consideration of difficult cases. We have recognized for hundreds of years that a jury's deliberations, discussions, and votes should remain their private affair as long as they wish it. Therefore, the law gives you a unique privilege not to speak about the jury's work. Although you're at liberty to speak with anyone about your deliberations, you are also at liberty to refuse to speak to anyone. A request to discuss either your verdict or your deliberations may come from those who are simply curious, from those who might seek to find fault with you, from the media, from the attorneys, or elsewhere. It will be up to you to decide whether to preserve your privacy as a juror. Ladies and gentlemen, thank you for your consideration. Thank you for your service. I know that everyone has somewhere else to be. I think Mr. Roper, you may be starting practice pretty soon. Maybe may have missed some of that. But you put all that aside and made yourselves available for jury service. Our system of justice would come to a grinding halt without citizens such as yourself. People can throw rocks at our justice system, but I would guarantee you that the vast majority of the world wish they could have this system. Their citizens come here and make these decisions. With that being said, that concludes your jury service. Remember to have take all your belongings, leave your notes or destroy your notes. If you'll follow the bailiffs in the back, they'll escort you to the parking lot. Thank you so much. All right. Is Ms. Heath, are we prepared to sentence today?
Yes, Your Honor.
Yes, sir.
The score sheet? I know there's a mandatory cost. What does that amount?
$250,000, Your Honor, and 15 years. Minimum.
That's for a civil judgment like the DSP.
Yes, yeah, I'll do all that.
And I have Ms. Heath at about 30 days to show that as well.
Do you agree with that? Does Ms. Heath wish to be heard prior to sentence?
I'm sorry.
Ms. Heath indicates she's fine, just have to be.
All right, Mr. Prince, I'm gonna, what I'll do is I'll allow the state to go first, and I'll allow you to respond to theirs to make your own one.
Yes.
So,
Your Honor, I mean, you heard the testimony. There is the minimum mandatory 15 years. I'm asking for a sentence of 20 years.
okay. Mr. Prince?
Your Honor, at 15, the punitive sanctions imposed by the Midman are obviously incredibly significant, especially given a relative lack of history. I would say that 15 years is certainly great enough to impose a punishment contemplated by the statute, especially when taken in conjunction with the score sheet, which is less than half of, looked like it was about half or less than half of the total.
Yes, ma'am. You can stay seated or you can stand, whatever you'd like to do.
Yes, sir. I have found out while I was in this courtroom that my uncle is having open heart surgery and he's not expecting to make it. Is there any way I could go home and close out my business and come back in 2 days, 3 days?
No, ma'am. And I'm not doing that just anybody that's convicted. I I remand them to custody. Okay? Regardless of the charge.
Yes, sir.
All right. Ms. C, you've been convicted by a jury of your peers of trafficking in methamphetamine, 200 grams or more. It's now my duty and obligation to sentence you. I've listened to the testimony. I've listened to your testimony. And what concerns the court the most is this is not an isolated incident. Maybe a part of a series of incidents. This time, you're adjudicated guilty of trafficking methamphetamine, 200 grams or more. You'll be sentenced to 20 years in the Florida Department of Corrections, given credit for 30 days time served. I'm going to assess fines and costs of $1,303. Those include discretionary cost of $2 of local law enforcement education, a $65 assessment district court cost, and a $50 drug abuse trust fund payment, and a $700 discretionary fine. A $250,000 fine, which is the mandatory fine for the trafficking in that amount. Those fines and costs are reduced to a civil judgment. There's no restitution after in the case. This is a 15-year minimum mandatory sentence. There's no restitution applicable. You have 30 days to file your notice of appeal. If you wish to appeal your judgment sentence, if you'd like to have an attorney to represent you, you can't afford one. One maybe if one represents you at no charge. Good luck to you, man. You step over big finger for me.
Yep. That's how it happened. That one's, I guess, just pretty astute observation. That one's going to be going to the same facility more than likely that Miss Boone might currently be in also. Sarah Boone? I honestly have no clue. It's not something I'm an expert on. What I am an expert on is saying thank you to all of you amazing people who have been hanging out in chat. Especially Darth Steven. Always. I gotta heart it. I gotta give it a heart. Darth. 20 years. Good, he says. I agree, Darth Steven. I agree. Darth Steven started the day off saying Happy Catterday with a super chat. And then Great Grandy came in saying hello to all the mods. Looking at you, Mom. Looking at you, Rhonda, out there somewhere. Nina out of the blue, just being nice with a little super chat. Vegas Starlight with an amazing super chat. Thank you so much for that, Vegas Starlight. That's, you just don't know. I've got puppy bills that I've been paying for, vet bills. It happens. They need to stay healthy. They're happy. Their tails are wagging every single day for no good reason whatsoever. And that's what we expect out of them, isn't it? And yes, Darth Stevens, 20 years. Good, good, good. Come back this evening. We'll have another presentation tonight and another live chat to hang out in and chat in together. It's going to be an interesting case with Judge Stevens, where he has a motion to revoke probation. And quite a few character witnesses going to be popping up. I need to get this little credit thing started. I'm excited to see this one. I haven't seen all of it. I've seen bits and pieces. I actually watched a little bit of this one with TCF, the courtroom files, on extended TCF. So I know people out there have seen it, and I know it's good. I've seen the Wolf Notes. Same Wolf time, same Wolf channel, 8 p.m. Central Time, 9 p.m. Eastern. Come on by, please. Hang out and chat. Say hello to everybody. But if you have other engagements with friends, loved ones, family, I hope you enjoy those also. And I hope you have a wonderful, wonderful weekend. What we're doing tonight is just a little get together. We'll have one tomorrow night too. Same time, same Wolf channel. Because you know what? I'm a wildly crazy old lone wolf oosel. And I just don't know when to stop. And I love all of you too much to stop. I think it's a great little place to get together and learn lessons together. These are cautionary tales that we can all learn from. That was just a stupid set of stories that there are so many reasons that you just don't do that. Don't do any of that. Like, Don't get involved with the cartel involuntarily and then start getting voluntold to do stuff. And just no, none of the excuses. Just don't get involved with any people. I'm gonna copy Phil DeFranco. Don't be stupid. Y'all have a good evening. Good afternoon. I'm your Lone Fusel. I am out. And remember, only you can take a bite out of crime. Why are you still here? What? You expect some weird Ferris Bueller? Yeah. Bye!